If Lordship, I would like to mention item number 32. It will come after 2 weeks. I have some problem today, Lordship.
32.
Yes, but I will found the problem.
Okay. On the prayer of Miss R.D. Mazumdar, Learned Counsel for the petitioner, matter stands adjourned for 2 weeks. It is submitted to Mr. G. Hendik, Learned Junior Government Advocate for the state respondent who is present. Kama has submitted that he has no objection to a prayer. Submit first of in view of the prayer made on behalf of the petition. Let the case be listed after 2 weeks on the date to expect.
May I please, Madam? Madam, in item number 5, I have filed one affidavit. I may be allowed to call that affidavit.
Item number 5.
5, I have filed one affidavit. I may be allowed to call that affidavit.
Okay. What is this?
Madam, land acquisition matter, Madam.
Okay, let it be with the record on Monday. Mr. A.K. Gupta, Learned Counsel for the petitioner, has submitted that in deference to the previous order, an additional affidavit has been filed, which is not on record. First of place the case on Monday with the additional affidavit, stated to have been filed already, on record.
All right. 2707.
Listing of a writ petition, Lordship, on Friday.
Motion.
May I please, Your Lordship? Lordship, the concern of the side, I beg to mention item number 45, Your Lordship.
Yes.
In this matter, we are awaiting instruction, Lordship.
Okay.
I've taken the
Why it
consent.
has come?
It comes to orders because steps on the pride respondent, Lordship.
So, objection 45 over. Which for the petitioner?
Your Lordship.
Mr.
N. Goswami.
N. Goswami, Learned Counsel for the petitioner, is present in view of the office note dated 16/6/2026. I wait for the service report in respect of the respondent number 10. Mr. R. Gogoi, Land Standing Counsel, Excise Department. Oh, let us have the patience. Court is looking at the record. Learned Standing Counsel, Excise Department, for the respondent number 126 has submitted that the instructions are awaited and therefore the matter be listed after 2 weeks or a few weeks. Post of in order to enable him to opt in the necessary instruction and to file the contract. J. Hendik 7 to 9. Is present. Release the case after 3 weeks on a date to be fixed by the office. The interim order passed earlier shall continue till the next.
The date may be fixed, Your Lordship, since the interim order operating.
Read your figure.
Published.
19th August, 1908.
May I please, my lord? My lord, I'm praying for listing of my writ petition, my lord, pertaining to second appeal before the Central Information.
Read your motion.
Yes, my lord, tomorrow.
Court master will give the date. Monday.
I have to mention for listing of a motion matter for tomorrow, Your Lordship.
What is the urgency?
Lordship, my GST registration has been arbitrarily cancelled, Your Lordship.
No urgency. It will come in
Friday,
due
Your
course. Due course. When it was cancelled?
Your Lordship.
Date.
24th, Your Lordship.
24th of?
This month, Your Lordship.
Huh?
This month, Your Lordship.
Today is 27.
18th, Your Lordship. That it was
18th of?
this month, Your Lordship.
18th of July.
Your Lordship.
Due course. No urgency.
May I please, Your Lordship? With the consent of the other side, I beg to mention item number 18. Respondent number 5. On behalf of S. Sharma.
18.
Yes.
You are for?
S. Sharma, Senior Counsel.
Respondent.
Respondent number 5.
Yes. What is your prayer?
So personal difficulties of my senior counsels.
You have informed the other side.
Yes. With the consent of the other. With the consent of the other side.
Okay. Your good name, please.
Y. Sharkar.
Y. A. Sarkar. Your name is not there. Learned Counsel, by paying for respondent number 5, has made a prayer for adjournment of the case for 2 weeks. So it is submitted that consent has been taken from the Learned Counsel for the petitioner and other respondents to make the prayer. First, the prayer is allowed. It is the case after 2 weeks on a date to weeks by justice.
May I please your lordship, I beg to mention item 21, the conducting counsel, K. Borough has some personal difficulties, lordship.
You are Miss M. Guya, learned counsel on behalf of the conducting counsel, Mr. T. Borua, learned counsel for the petition, has made a prayer for adjournment of the case. First up, as paid for, release the case after 3 weeks on a date to fixed by the office.
May it please this, my lord. My lord, I am praying for some accommodation with respect to item number 20, my lord, of the daily list. I
Yes.
have taken the consent of the other side, my lord. I am praying for 2 weeks' time to file our affidavit in opposition, my lord.
Okay, Mr. Mishra, you have informed.
Madam.
Mr. Mishra, R.S. Mishra, learned counsel for the petitioner is present. Mr. H. Borua, learned counsel on behalf of Mr.
Be Google, my lord.
B. Gugoi, learned standing counsel, finance and taxation department, government of Assam has prayed for and is granted 2 weeks time to file affidavit in opposition. First up, release the case after 2 weeks on a date to fixed by the office. The interim order, if any, past alia shall continue till the next date of listing.
Concern of the concern of the other side, my lord. I beg to mention item number 24.
24. You are for petitioner or respondent?
My lord, I am for the respondent, my lord.
Huh?
This case, they have taken 2 times, my lord. The affidavit is ready. Thus, they have executed the affidavit. Close to
No,
file.
who is for the petitioner?
I am for the petition.
Already, lord, see, 50% comments already released, my lord. If to file this petition, my lord, 50% comments did not release. So, what can be date?
So- You want to file affidavit or what?
My lord, affidavit in reply, my lord.
Okay, Mr.
Yes, Abdullah.
S. Abdullah, how much time you need?
My lord, we'll file it by tomorrow.
Okay.
1 week.
Mr. S. Abdullah, learned counsel for the petitioner, has prayed for and is granted 1 week time to file an affidavit in reply. Post of Mr. J. U. N. M. Loskar. You are for whom?
The respondent numbers 6 and 7, my lord.
6 and 7 is present. Post of. It is submitted that consent has been taken from the learned counsel for the other respondents to make the prayer. Lays the case on such.
5th August 0508.
There is an interim order.
Interim order, if any past earlier, shall continue till the next date.
Item number 15.
Item number?
15.
Yes.
Listen, I want to withdraw this because of
Okay.
the
Mr.
visit of doctor.
P.J. Datta, learned counsel for the petitioner, has submitted that he has instruction from the petitioner not to press the read petition. Mr. J. Hendrik, learned junior government advocate Assam, for the state respondents is present. In view of the above submission made by Mr. Datta, learned counsel for the petitioner, the petition is dismissed as not pressed.
What is my beg to mention?
Lordship, I pray for liberty, Lordship, for filing a press, Lordship.
With liberty could you.
Obvious.
What is beg to mention item 38, my lord. We need to file reply.
Item number
38, my lord.
38.
38, my lord.
T8.
38.
Okay. You are for respondent.
Yes.
You want to file counter or what?
No, reply.
What reply?
Reply to the writ petition file, my lord.
So counter affidavit,
Yes,
affidavit
my
of
lord.
opposition.
Yes.
Mr. A.K. Sahiwala, learned counsel for the respondent number 1 to 4, has paid for 4 weeks. How much time?
4 weeks, sir.
4 weeks time to file affidavit in opposition on behalf of the said respondents. Post up. It is submitted that consent has been taken from the learned counsel for the petitioner to make the prayer. Post of the prayer is allowed, leaves the case after 4 weeks and ready to be fixed by the office.
My lord, one small prayer, my lord. In this, we have for 1 to 3. By mistake, while filing the Wakalat Tamano, it was
1 to 3.
1 to 3. Great.
Lordship, since learned counsel could not appear.
Your
Difficult.
name, please?
R.I. Khan, on behalf of Essex Sector.
has made a prayer for adjournment of the case. Post of Mr. and Miss N. Bordole, Standing Counsel Revenue,
Oblige, Your Honor.
and Mr. J. Hendrik Lanet, Junior Government Advocate, some for the official respondents are present. In view of the prayer submit, this is the case after 2 weeks on a date to be fees made.
Daily list for motion, item 1.
May please your lordship. Lordship, the judgment that I have challenged here in lordship, the division bench of the Honorable Court has stayed the lordship judgment. So, division bench
Stayed.
for a timely definite close.
Okay. Mr. J. Colita, Learned Counsel for the petitioner, has submitted that the impugned, the judgment and order dated operation of the judgment and order dated 27/3/2026 passed in
In a writ appeal-
WBC number 7173/2025 has been stayed by the division bench, has been stayed, in the meantime, by the division bench of this court. Post up. He has therefore submitted that he is not pursuing the present contempt, the instant contempt petition at this stage, with the liberty to approach again after the decision of the division bench.
I'll come
Post
with.
up. In view of the above submission made by Mr. Colita, Learned Counsel for the petitioner, the contempt petition is closed, at this stage, and with liberty as sought for.
Lordship. Good lordship.
Item 2.
Item 2, Lordship, I have received the parawise comments. So I'm going to file an appeal.
Let us see what is the situation.
Lord, situation, my lord, that the tendency, my lord, that case, Lordship, the hearing was conducted on Lordship 35/2023, 23/6/2023, 28/23, 16/7/24. My lord, so many dates is there. My lord, hearing was conducted. And after my lord, the hearing, my lord, the court was directed to both the parties to settle the amicably. My lord, it was not been done, Lordship. So due to my lord, some election process, my lord, it cannot be completed. Now, my lord, they are seeking, going to be, my lord, within a short time, it will be, my lord, process. As per my lord, that parawise comments.
You complete as expeditiously as
Lordship,
possible.
Lordship, Lordship.
Within a period of 3 months,
Lordship,
let us see your instruction.
Lordship. Paragraph number 6, Lordship.
Third, Mr. Asnath, Learned Counsel for the petitioner, N. Bordole, Learned Standing Counsel, Revenue Department for Respondent number 1, and Mr. J. Hendrik, Learned Additional Senior Government Advocate Assam for the Respondent number 2 and 3.
Lordship, junior government.
Junior Government Advocate. First up, the petitioner has approached this court by filing the present writ petition under Article 226 of the Constitution, aggrieved by non-disposal of tenancy case number 04/2023, which is stated to be pending before the respondent number 2 till date. Full stop. It is the case of the petitioner that the proceedings of tenancy case number 04/2023 is for the purpose of ownership right in favor of the petitioner as the applicant under section 23 of the Assam within bracket temporary settled areas bracket close tenancy act, 1971 full stop. Para. As the tenancy case is stated to be pending since 2023, the petitioner has approached this court for an expeditious consideration and disposal of tenancy case number 04/2023. Para. On 13/7/2026, the Junior State Council was asked to obtain instruction regarding the present status of tenancy case number 04/2023. Para. Today, Mr. Hendrik, Junior Government Advocate, appearing for the respondent number 2 and 3, has submitted, on the basis of instructions, written instructions received from the respondent number 2, provide an office letter number so and so, dated 17/7/2026, addressed to him, that the hearing of tenancy case number was held on 35/2023, Lostaman data, para 6 to 11/2025. First off, it is mentioned that during hearing, opportunity was granted to the contesting parties to resolve the matter amicably. And first of on 11/2025, the parties were granted 1 month time to submit their respective written statements to objection in the matter of transfer of ownership rights to the riots. First of. It is mentioned that further hearing was not conducted for a period of 3-4 months due to the election to the Assam Legislative Assembly in April/May 2026. First of. It is mentioned that the case will be disposed of within at the earliest, first of para, in view of the pendency of tenancy case number 04/2023. First of, considering the fact that tenancy case number 04/2023, which is presently pending before the respondent number 2, and the hearing has taken place from 35/2023 onwards. That is for more than a period of 3 years. This court is of the considered view that the respondent number 2 shall bring the proceeding of tenancy case number 04/2023 to its logical conclusion as expeditiously as possible, preferably within a period of 3 months from the date of submission of a copy of this order by the petitioner. Copy of this order in the office of the respondent number 2 by the petitioner. It is accordingly ordered. Full stop. With the above direction, the petition is disposed of. Full stop. It is clarified that this court has not made any observation as regards the merits of the claim of the petitioner in tenancy case number 04/2023, and the respondent number 2 shall proceed to dispose of the case on its own merits and in accordance with law. A copy of the office letter number so and so dated 17/7/2026 of the respondent number 2, which is placed by Mr. Handy, is kept with the case record by marking it as document X.
Item 3.
As per our last request, Your Lordship, I filed additional affidavit, but it's not placed on record yet.
What is the last order?
I prayed for filing the additional affidavit.
You have prayed for?
Yes, yes. This one, filing number is 74/26.
Mr. In Ajay Lani, counsel for the petitioner, has submitted that an additional affidavit has been filed by the petitioner, and the said additional affidavit is not on record. Full stop. He has sought for listing of the case on another date with the said additional affidavit on record. Mr. J. Handy, and the junior government advocate Assam for the state respondents is present. In view of the, so let the case be listed next Wednesday with the additional affidavit, stated to have been filed already by the petitioner. Come on record.
2907.
My lord, it'll be on the first week of August. I have some difficulties.
0308. Item 4.
Yes.
May I please, your lordships? In terms of order dated 13/7/25, file
minute.
additional affidavit, lordship, but that is not on record. I checked.
Okay. A few more Bhuya. Petitioner. Central Government Council. Okay. S. Kakoti, 1. N. Bordule, 2. J. Hendrik, 4 and 5. R. Bora, NHITCL, 6. Mr. Bordule has submitted that an additional affidavit has been filed in reference to the order dated 13/7/2026. Full stop. However, the said additional affidavit is not on record. Full stop. In as the additional, sorry, I got to second. Wednesday
29.
or Monday.
26, lordship.
I got to second on record.
Monday. Obliged.
Item 6.
May I tell you?
Yes.
Hearing this case, my lord.
Anshalik Panchayat.
Total 15 Anshalik Panchayat, my lord.
You are Anshalik Panchayat member.
Members. Out of 15 minutes, we have the six petitioners, my lord. Initially, my lord, 26/2011. 26.
You are agreed by what?
My lord,
Non-allocation.
yes, my lord.
Have you preferred anything before Zila Parishad?
No, my lord. Policy is,
No.
7, my lord.
Your higher authority is Zila Parishad.
Yes, my lord, we will approach the authority, my lord.
Have you approached?
Yes, I approach.
Where is that?
Bharveli, my lord.
Oh, Bharveli will not do.
Bharveli.
Thereafter, you have
We will
to,
approach the authority.
Director of Panchayat and Rural Development, State.
No, my lord.
Is it the way, without approaching the higher authority, you come running to the High Court?
Hearing this case.
Everybody has a fashion now.
My lord, a total violation of the.
Where is
guidelines, my
it?
lord.
Where is it? Have you approached? Without approaching Zila Parishad, jurisdictional Zila Parishad, where is it? Is there anything?
I is stating in the petition, my lord.
No. Where is that representation?
No, my lord.
Everybody says, I have approached verbally. But your jurisdictional authority, higher authority is Zila Parishad, is it not?
They are the involved in this.
Huh?
Jila Parishad. my
Then
lord,
director of
executive
Panchayat and Rural
ex-
Development,
Executive officer. my lord.
whether there is a director of Panchayat and Rural Development,
They are the higher authority.
then there is a commissioner and secretary.
Yes, yes.
These are the official channel. Why this repetition is to be entered? Without approaching the higher authorities. Why we should entertain this?
I mean, my lord,
We do not have expertise unless they decide something on it.
that may be taken up after tomorrow. my
No,
lord.
I'm
We
dismissing.
take instruction. my lord.
No instruction. Have you annexed or not?
No, my lord.
Let us, I'll go one by one.
No, my lord.
What is your Anchalik Panchayat?
Dolgaon Shialmari.
Where is the amount?
Yes, my lord. Amount is my lord pays. Page 63, my lord.
A63.
Serial number 43.
Tolgaon, Kialmari.
Yes.
How much amount?
Page 63.
30.56 lakh.
30.56.
Hmm.
And my lord, prior to that, my lord, page 56.
Page?
Serial number 43.
Page
56, serial number 43. Yes,
34.38.
yes.
These were allocated to Anchalik Panchayat. In pursuance of sanction for an amount of the second installment. Now, 26/11/2025. Page 69. What is this? Executive
69
Committee of Dolgaon so-and-so was held. Discussion were made
meeting, my lord.
in respect of preparation of scheme for tied and untied fine under so-and-so. Representative Salma Sultana.
Executive meeting.
Represent, according to committee adopted the below mentioned resolution. The president of Anchalik Panchayat video and with the consent of all them decided to prepare scheme for 50% of the time fund and under the major. Accepted the chance to distribute equally among all the members of the Anchalik Panchayat. Second resolution, page 70.
Yes, that is the resolution, my lord, 2025, my lord, 26/10/11/2025, my lord.
No, page 70. That is a resolution 26/11/2025 of the Anchalik Panchayat.
Yes,
Their second resolution is that scheme should be distributed among all the members equally, right?
that was not.
They have held, right?
Yes, my lord. And another.
Then again,
Again, my lord, page 87, my lord. in
87.
24 scheme, my lord. Where, my lord?
87.
Yes, 87 million. Only one scheme allotted to the petitioners million each. And two to three schemes million, they are allotted million, higher funding.
So dismissal, directly you have come. Dismissal,
No,
directly you have come.
million.
No point spending time here.
But I may be.
Anchalik Panchayat members.
The day, I mean, have me take the day after tomorrow.
No.
I'll take instruction.
No, no,
Whether they filed or.
No, it is not there. Not there. You approach. Where is your statement?
Yes.
Verbally.
Mm.
Verbally will not act anybody. Heard Mr. A.M. Ahmed. Which paragraph?
I mean, if dismissal, I may be allowed to withdraw million.
I'm saying it because you have to approach
Yes,
at least one authority. At least one authority, higher authority. One is Zilla Parishad.
Yes.
There is Director of Panchayat and Rural Development, is it not?
Yes.
Or Commissioner.
Yes.
Commissioner. Then either or Commissioner Secretary, State Government. Or you directly run to the High Court. As if it is a 100-meter race. No.
I may be allowed to withdraw million.
Mr. A.M. Ahmed, learned counsel for the petitioners, has submitted that the petitioners may be allowed to withdraw the petition, in order to approach the higher departmental authorities first with regard to with their grievances, with their grievances. Approach. If they do not respond, then only Ms. P. Thapa. We do not run government. We do not run government. Department runs the government.
Yeah.
On behalf of Mr. S. Doctor.
1, 2, 3.
Learned Standing Council, Panchayat and Rural Development Department for the respond number 1, 2, 3, 5, 6,
8 and 9.
8,
9.
9. And Mr. N. Goswami, Learned Junior Government Advocate Assam for the respond number 4 are present. In view of the above submission made by Mr. Ahmed, Learned Counsel for the petitioner, the petition is dismissed as not placed at this stage. First of at this stage, as the petitioners are to approach the higher departmental authorities first with regard to their grievances at this stage.
Okay.
Item 7.
My lord, in this case, my lord, the mother of the petitioners died due to electric shock. Therefore, the notice may be issued. In the meantime, they obtain instruction and file their evidence.
Heard, Mr.
Zio Ahmed.
Learned Counsel for the petitioners. Mr. You represent one also?
No, my lord.
Mr. N. Goswami, Learned Junior
One and
Government
three.
Advocate Assam.
2,
For
4,
the
5,
respond number 1,
and 3.
3. And Mr. B. Chaudhary, Learned Standing Counsel APDCL.
For 2, 4, 5, and 6.
2, 4, 5, and 6. Post of para the petitioners. Are sons of one, Joya Bormon. The petitioner stated that Joya Bormon died on 24/5/2026 due to electrocution. when she came in contact with a live electric wire which had already fallen, live electric wire on the ground. Post of issue notice returnable. Post of seeking a direction to the respondents to pay compensation due to their act of negligence. The petitioner has preferred the instant petition. Issue notice returnable in 4 weeks. As Mr. Gustami and Mr. Choruri. No formal notice. Post of. The respondents are to bring their stands by way of affidavits on or before the returnable date. Post of the respondent number 3 and is required to bring the electric accident inquiry report on record in its affidavit.
Item 8.
May I please, Lordship, we are the President and Secretary of Gauripur Kobristan, Lordship, Graveyard. And that Kobristan was established during the year, Lordship, 1960, over a plot of land measuring 2 bigger, 3 gata, 1 lesser. Lordship,
You are Kasim.
Lordship, we are President and Secretary of that Kobristan, Lordship.
Gauripur Town Kobristan Committee. Yes.
Lordship, in course of time, what happened, that Kobristan, that graveyard became overcrowded, so it could not, Lordship, accommodate the corpse. And as a result of which, the subsequent land, the adjacent land measuring 11 bigger, 2 kata, 3 lesser, which was lying vacant and abandoned land. And
How can it be say just because it is vacant? So you go and get it possessed.
Lordship,
Is it a patta land or government land?
Patta land, Lordship.
Patta land.
Patta land, they didn't raise any objection, Lordship. The patta there, the owner of those, that land didn't.
That is not the question. Your act first. Going into somebody else's land.
Yes.
Patta land.
Lordship. We are in.
I can measure the 10 circle location. Where is your first mutation order? First mutation order. First mutation order.
So kindly,
Mutation order in your favor.
in my favor. Lordship.
Where is that?
Lordship, page 15, Lordship.
Page?
Page 15.
15.
15. This petition has been made by the private respondent.
No. You said that circle officer by order dated 30/11/2020 in mutation case number so and so. Where is that order?
That was admitted by the petitioner.
No, that was admitted. I am asking you something that where is that order? You started making submission that is admitted by so and so. Is it annexed or not annexed? That is the answer.
It is not there. Lordship.
It is not annexed. So what is the status of the two title suits? Next date is 31/7.
Notice issued. And
Next
one
date is
is
31/7.
31/7, Lordship, 31st of.
Mutation is only, mutation does not decide any title.
Lordship.
Mutation does not decide any title. If it is a case of fraudulent mutation, maybe he has the power. Otherwise, it is a jurisdiction of the appellate authority. But otherwise, if it is a case of fraudulent mutation, he might have the power because fraud vitiates everything. And if it is ovoidho, then ovoidho. Let us issue notice, or you get the status, what is the order passed in title suit on 31/7/2026.
Then Lordship.
Will not pass any interim order as on date. You get the order, copy of the order to be passed on 31/7. That too, both the parties have
Yes.
filed title suit,
Yes.
right?
Yes.
So your case, any injunction order has been passed.
Lordship, here I am relying on two judgment of coordinate bench of this honorable court. Lordship. Kindly have a look, Lordship.
Then I am relying on few more. You get the status of the order on 31/7, we'll defer it, but this pendency of the writ petition shall not, will observe that the title you should not present the order of this court to influence the title suit. don't present any order of this court before the trial court to influence the decision of the trial court.
Lordship.
Heard Mr. A. Islam, learned counsel for the petition. Yes, Mr. Goswami.
Lordship, in the impede order, Lordship,
I have
as
seen.
per the circular officer, one thing mentioned, Lordship. Page 43.
Why don't you challenge this in appeal?
Lordship, this is a matter of title. I have already approached
No
the
title.
competent civil court.
I can
Lordship.
clarify mutation of a land
Lordship.
in the revenue records does not create or extinguish the title. That much is clear.
Lordship, ultimately.
However, how much you argue, law is settled. Mutation does not create or extinguish right, title, and interest over a plot of land. It
That
is
I
only
understand.
for revenue records
Lordship, that I
to
understand.
deposit khazna.
Lordship.
You may argue for 10 days. I'll simply say that mutation does not create or extinguish title.
That's exactly what.
So that is not the question. Now, when the trial court are proceeding with two title suits, it will be subject to the outcome of the title suit.
Yes.
Ultimately, will be bound by
Or
the-
otherwise, there is an appellate remedy before the
Deputy Commissioner.
Deputy Commissioner under section 147. So why we should entertain a parallel proceeding?
Lordship, my limited fear here in this repetition, Lordship, while the title is adjudicating by the competent civil court, Lordship, the matter is
That
under
can do.
adjudication by the competent civil court.
Yeah,
Lordship.
he can do that mutation part. The circle officer, district commissioner, and board of revenue has exclusive jurisdiction, but they do not have the jurisdiction to decide title. But once title is decided, possession is decided, confirmation of possession is there, mutation will automatically be upturned.
Yes.
Because it is for revenue purpose to deposit the revenue to the state.
As per possession, Lordship.
Possession is 53A,
53, Lordship.
but that is a summary one. That is but real mutation is section 51, 52,
But Lordship, my humble.
not 53A.
Lordship,
It is during field,
During field mutation.
during field mutation.
During field
But real mutation is under section 50,
under section 50.
right? You file an appeal.
Lordship, here, Lordship. my-
Mutation, I'll observe, mutation is not created, though it is contended that circle officer has, you are saying in your synopsis,
Lordship, circle officer has acted as an appellate authority, Lordship. The earlier order passed by the circle officer,
So this-
the then circle officer, Lordship.
if
that
it is
cannot be
vitiated
answered
by
up
fraud, he said vitiated by fraud, then he may derive jurisdiction.
How
Let
can-
the,
Lordship, how can circle officer?
you have an appellate remedy.
Lordship.
Go and argue there. Why should we decide? Just because two title suits are there on the basis of, regarding title, you have a weak case. So you come here in a writ petition, no, will not entertain.
I am,
Art.
Lordship,
Mr. It is settled. Title cannot be decided by mutation procedure. You contended that action of circle officer
my humble.
interfere with the title of the subject land is totally illegal. Well, there is nothing in the order that he has decided on title. You file an appellate remedy, say
Lordship,
volume 1,
Lordship, my
heard Mr. A. Islam, learned counsel for the petition. When there is an adequate remedy, why don't you prefer it?
Lordship, here is the impending order, Lordship.
I have perused twice. Last page. I have perused. অবৈধ
Lordship.
অবৈধ নথি. That means it is of some fraudulent character.
Lordship, that has to be proved in the.
Is it an appellable order or not?
Yes, it is applicable order, Lordship.
Heard. I'm holding it that this is an appealable order which can be appealed under section so and so.
Lordship, the
So you get
frugal
it
and-
after and before the larger bench will hold in your favor. Because any decision here will influence the trial court. And mutation is not the end, it is the title.
Lordship.
And borderline. Revenue and Disaster Management Department for the response number 1. I'm not foreclosing your remedy. You have a remedy, Mr. Islam. And Goswami Lana Junior Government Advocate Assam for the response number 2. Para. The petitioners are the president and the secretary of 1 Gauripur Town Kabasthan Committee, which is stated, it is stated that Gauripur Town Kabasthan, within bracket graveyard, was established in 1960s over a plot of land measuring 2 bigha, 3 kothas, 1 lesa, covered by tag number 234 within bracket old stroke 1381 stroke within bracket new, under Khotian number 387, including a portion of khas land measuring 1 bigha 4 katha 19 lesas, covered by tag number 1382. Both the plots of land are situated at Gauripur in ward number 4 of Gauripur town. However, with the passage of time, it is stated that with the passage of time, the graveyard became overcrowded and was unable to accommodate the burial of corpse. Then, the committee finding the adjacent land measuring 11 bigha as 2 kathas 3 lesas, covered by old dag number 236 under Khatian number 387, within make a subject land, was being the committee started using the adjacent plot of land measuring so and so as a burial ground, finding it vacant. The then circle officer, Gauripur Revenue Circle, by an order dated 30/11/2020, passed in mutation case number DSU/ZPR/2020-21/1537/FNUT, had mutated the subject plot in favor of the Kabasthan. Para. On 6/2/2026, the respondent number 4 and 5, claiming to be power of attorney holders of the owners of the subject land, file an application before the circle officer, Gauripur Revenue Circle, Gauripur, within bracket respondent number 3, seeking cancellation of the mutation order dated 30/11/2020. The respondent number 3 even despite submission of a said application after a long gap from 30/11/2020, gave consideration entertained the application and issued notice to the petitioners on 6/3/2026 for their appearance and submission of written statements. Post of para. Doubting the intention of the respondent number 3 and the respondent number 4 and 5, the petitioners have instituted a title suit, title suit number 71/2026, claiming title on the basis of adverse possession and walk-off by user. Posto. An application under Section Order 39, Rule 1 and 2 of the CPC was also filed along with the title suit, and the said application has been registered as Miss J case number 126. Posto. The hearing of Miss J case number so and so is scheduled today.
Today, Lordship.
Okay. Is scheduled on 22/7/2026. Posto. Para. On the other hand, the respondent number 4 and 5 have also instituted a title suit, title suit number 35, along with an application under Order 39, Rule 1 and 2, which has been registered as Miss J case number 74/2026. Posto. It is stated that the hearing of Miss J case number 74/2026 is scheduled on 31/7/2026. Posto. Para. It is the grievance of the petitioners that without waiting for the outcome in the title suit, the respondent number 3 has proceeded to pass an order in the application filed by the respondent number 4 and 5, which has been registered as case number ZMC/MISC, page 44, /2026/16, on 14/5/2026. Post by the order dated 14/5/2026, the respondent number 3 has cancelled the Coverstan's name by setting aside the earlier mutation order dated 30/11/2020. Poster. The petitioners have contended that by virtue of the impugn order, the respondent number 3 has acted as an appellate authority, adjudicated upon the title of the subject land without jurisdiction. Post-op. It is contended that Gauripur Town Kabristan has acquired bona fide title over the land by virtue of adverse possession and walk-up by user. And as such, the Action of the respondent number 3 in deciding the title of the land, subject land, is totally illegal, arbitrary, and without jurisdiction. First of more so, when the matter is pending adjudication before the competent civil court. First of para. This court. First of the contention that the respondent number 3 by the impugn order dated 14/5/2026 has decided has adjudicated on the title of the subject land, without jurisdiction, is not acceptable. Full stop. Mutation of a land in the revenue records does not create or extinguish the title over land Full stop. A mutation order does not have any presumptive value on the title, and it only enables the person in whose favor mutation is granted, mutation, if ordered, to pay the land revenue in question. Full stop. A mutation entry para 6 and 7. Para 6 and 6.1. Para. An order the order, moreover, the impugn order dated 14/5/2026 is an appealable order, and against the said impugn order, an appeal will lie under Section 147 of the Assam Land and Revenue Regulation before the Deputy Commissioner. Under 147 of the Assam Land and Revenue Regulation, first of all. In view of availability of an efficacious, adequate, and statutory remedy of appeal to the petitioners, this writ petition is not entertained, reserving the liberty to the petitioners to avail the appropriate remedy of appeal before the competent appellate forum, before the appellate authority. First, para, before I vote. As the contesting parties have already initiated 2 title suits, title suit number so and so, and title suit number so and so, against each other and the said proceedings of the said two title suits are presently pending, comma, are presently pending. That's all. As not like it. Appeal.
Item 9.
Make please your lordship. But the petitioner is a Vaishnavite Satra, having a portion of land settled with them way back in the year 16, during the period of Ahom Kingdom in the year 1654 to 1663. Now, in recent times, it came to the notice of the Satra that this particular land is being occupied by respondent number 4, and they have leased
Four.
out. Yes, this is the Assam Tourism Development Corporation, and they have leased it out to respondent number 5, and there is a resort which is functioning. Now, straight away, this matter was first of all taken up by the petitioner Satra before the respondent number 4 at page 50, a type copy of page 50A. And pursuant to the RTI application by the petitioner Satra, this is the reply that they have given at page number 50. 50, type copy of 50A, wherein, my lord, the
50, 1 minute, 50, A or 50?
my lord, one is the type copy, one is the original copy. Now, here they have contained.
Let me read.
My lord. Now, pursuant to their contention, they have entered into a lease with respondent number 5 that I have annexed at page number 51, which they communicated to us. Now,
property belongs, according to them, property belongs to them. They have let out
yes,
the complex to respondent number 5.
yes, and they are contending that the government of Assam Revenue Department has settled the land with them. Now, your lordship kindly takes up page 57, which is the type copy, and 58 is the original copy. Page number 57. This is a report by the circle officer who is arrayed as respondent number 3.
Now you want the tourism ATDC to hand over the possession.
My lord, we represented before the Department of Revenue that your lordship will find page 64.
It does not appear to be a high-handed action.
From our side, my lord.
Because where is the lease?
Well, the lease that that was entered between the respondent number 4 and respondent number 5 is at page 51.
Date?
Date this
2002.
Well,
my God.
But this came to our knowledge pursuant to this RTI reply.
RTI, meaning thereby you have kept your eyes closed.
My lord, subject to my
kept your eyes closed. A big
my lord, understand.
Resort is operating since 2002 in front of you, and you have chosen to maintain silence.
My lord, that aspect.
It is not a case that because your private entity, your patta,
My lord.
land, somebody, even if it is an instrumentality of the state, it is not that they have evicted you,
My lord.
evicted you,
My lord.
right? Demolished all your properties by way of high-handed action.
Well.
They have come, they have constructed, they have leased out everything,
Well.
right? Now, with 20 land was handed over,
My lord, as per their RTI reply, they are
RTI,
saying that was.
whatever, but this agreement is in existence.
Yes, my lord.
It cannot be denied,
Yes.
right?
Well.
About 25 years have gone
Well.
by. Construction was made
Well.
of a big resort
Well.
building.
Well.
So, why will adjudicate this prayer? This is a case of,
My lord, I understand, my lord. So far, the barrier of time is concerned.
no, it is a case, it is not a case of high-handed action.
I understand, my lord. I
If-
understand. Only
If
thing.
it is a case of high-handed action, yes, jurisdiction of 226 is available.
My lord.
But if it is by way of, even if it is government,
Well.
even if it is instrumentality of the state,
Well.
they have taken over possession of the land,
Well.
periodic pata land.
Well.
Then what is the remedy?
My lord, one thing, if I may be allowed to point out, at page 60, my lord, the sequence of events which your lordship has taken notice of 2002. But your lordship will kindly see at page 60, this is a challan of the land revenue that has been paid by the petitioner Satra to.
That is collection of revenue.
My lord, but this
But
amount,
it is a case of possession.
I understand, my lord, but
It is
there,
a case of possession,
my lord,
right?
understood. Only problem, my lord, is that now they have taken position on the garb of there being some kind of acquisition, which they are saying.
Not acquisition.
They are saying, my lord, your lordship kindly see page
See,
50.
page 51, I always read vernacular, original.
Offer was published in Assam Tribune.
No, page 50, if your lordship kindly sees paragraph 2.
50, I always read the original, whatever, even if it is illegible.
Yes, yes. Page
50A,
Paragraph 2, your lordship kindly.
Four also.
Paragraph 2, paragraph, not least. So, one difference. Now, they are talking about acquisition.
not acquisition.
Yes, your lordship sees paragraph 2. Yes, the Revenue Department, Government of Assam has settled the said land in favor of APTC by duly handing over the same through concerned mandal on so and so in accordance with official order of land
We will
acquisition.
simply issue notice,
Oh, my lord.
nothing else, Mr. Otherwise, there might be, you have not brought all things
My lord.
because it has been made khas. Your revenue receipt, let us see first.
My lord.
For which period you have
My lord,
deposited?
this is up to 2023.
Not up to, from.
From 1/4/2022 to 31/3/2023.
Where is the other revenue receipt?
Those are there.
Because
I am.
might be by way of proceeding, when these authorities were not there in the helm of affairs of Hotra,
My lord.
might be it has been notice have been issued thereafter this plot of land might have
My lord. My lord.
made khas.
My lord. My lord.
And thereafter government derives all the right
My lord.
to settle.
My lord.
I can see what is not disclosed.
Understood, my lord. Understood, my lord.
But you have to give some better particulars.
My lord, though I have contended that we did not get any notice of acquisition as is required under the Assam
Right.
State Acquisition of Land belonging to Religious and Charitable Institution Act 1959. We have made a statement to that effect, but my lord, let a notice go. Let them come up with a response.
No, you get something better. I'll give you some more time.
Lordship, ATDC made the offer in the Assam Tribune paper, Lordship. That That the deed of agreement, paragraph 4, Lordship, it is categorically mentioned. Page
Yes,
51.
that is their contention. That is what I
51
have
paragraph 4.
annexed.
No, why, have you made inquiry that why Revenue Department? Revenue Department, it is presumed that Revenue Department is conscious enough to hand over the possession of the land.
Well,
I have never come across Revenue Department handing over periodic patta land
to another
to another state entity. I have never come across. Maybe Revenue Department does this and that, but without ascertaining from the revenue records, they do not hand over possession of the land,
Yes.
private land, to another Article 12 entity. So there is something which is not disclosed here.
that is why page 64. Page 64
Your
was,
Khazna receipt.
no. Page 64 was
That's
my,
the representative.
that has been received also by them. I have enclosed the postal receipts, the postal tracking, but they are yet to come up with a response. Well, from my side, my lord, last remedy has been exhausted.
Last remedy, but
My lord,
not.
had they come up with a
Facts are,
reply?
no.
I'll-
Mr. Chakraborty, people are coming here that I am filing the petition.
my lord,
Court, you make the investigation.
Well, I'm not asking for that, madam. The only thing is, let them respond.
Everybody comes with that. I'll not exercise due diligence. Let court do the investigation.
Well, no, that is not.
This
right.
is, appears to be anyway. Since it is not a private entity, so I am issuing notice on it.
I'll
Right,
agree.
Mr.
Good.
I'm issuing notice.
Good.
Had it been a private entity, I would have dismissed right now. The Chakraborty petitioner. And Board of Revenue. And Goswami,
2 and 3.
2 and 3.
Notice of
Double A, 4 and 5.
As per Honorable Supreme Court's judgment in Maqbul Ali, it is a case of civil suit. It is a case of civil suit. On the next date, we will also. Issue notice. I cannot say anything.
Well,
Nothing in this case.
Well.
Issue notice. Returnable in 6 weeks. As so and so and so. Appeared accepted. No formal notice. Extra copies. Step 7 respondent number
4 and 5.
4 and 5 by speed post within 2 working days.
I'm grateful.
Item number 10.
May it please your lordship. Lordship, this is yet another
How
similarly.
many are there?
Lordship, there will,
You are coming up with piecemeal. File all the, there are hundreds.
we actually filed everything together.
You
but
come with one every day.
Initially, we did one, then we were directed by this honorable court to file them based on their ancestral, the names of their ancestors were differently put in Khatyans, your lordship.
Heard, Mr. Where is my previous order?
Page 30, your lordship.
No, in one order I have passed recently. 2 days back. It is like that.
No, the recent one had 3 private respondent, your lordship. This is similar to the page 30, the one annexed in page 30.
Same. Other part is same. Where is it? WBC order?
Page 30, your lordship.
Not. My order. Heard, Mr. I.S. Majorpuri. Learned Counsel for the Petitions. And Board of Revenue 1. H.K. Hazarika, 2, 3, and 4. The petitions have claimed that at present, they are in possession of the following parcels of land. Page 5 or A, B, C, D, S. It is a case of the petitioner that the aforesaid 4 parcel of land are part of original Khatian number 173 of village Kothaldi part 2, which comprised of an area of land, a total area of land measuring 68 bighas, 3 kathas, 8 lessas. Posto. The old Khatian number 173. It is stated that old Khatian number 173 was issued in favor of the successors or predecessors in interest of the petitioners. Posto. Whereas it is the further case of the petitioner that Khatian number 173 was issued in the name of their successors, predecessors in interest of the petitioners under the Gwalpara Tenancy Act 1929, which was subsequently repealed by the Assam Landholding within bracket adoption of relationship under the Assam Land and Revenue Regulation, para 9 1886, in the acquired permanently settled estates, bracket close, Act, 1974. Full stop. The land, the parcel of land, the total area of land, and the old Khatian number 173 had thus come under the direct ownership of the government of Assam by virtue of the Assam State Acquisition of Zamindari Act, 1951. Full stop. Para. The petitioner's case is that by virtue of Section 4 of the Assam 1970 of Section 4 of the 1974 Act, they as tenants occupying the aforesaid 4 plots of land have acquired the status of landholders by operation of law, and therefore they are entitled to get pattas for the aforesaid 4 plots of land on payment of revenue. Post of para. The petitioners have expressed have raised an apprehension that the state respondents are claiming that the 4 plots of land have become khas and are in contemplation to evict the petitioners from the said 4 plots of land at any time without serving any prior notice to them. Those para. Issue notice returnable in 4 weeks. As so and so has appeared accepted. No formal notice. Extra copies within 2 working days. Post of. Having regard to the apprehension raised and the projection made as regards the right of the petitioner, comma, it is ordered, comma, in the interest, it is ordered, comma, in the interim, in the interest of justice, that status quo as regards the 4 plots of land mentioned in paragraph so and so above be maintained by the parties till the return report.
Obliged, your lordship.
May I please, your lordship? My lord, may I also kindly take up item number 14, similar as
14.
well.
Yes.
So, my lord, the petitioner before your lordship is a successful resolution applicant under the IBC, that is, my lord, the Insolvency and Bankruptcy Code, for one company which is known as Ruchi Soya Industries Limited. Now, my lord, the erstwhile Ruchi Soya Industries Limited were assessed with certain demands under the Assam Value Added Tax for the financial years 11-12, 12-13, and 13-14. Thereafter, my lord, the erstwhile management of the Ruchi Soya Industries had preferred a revision petition against those assessment orders. Now, my lord, pending the revision application, CRP proceedings, that is, my lord, corporate insolvency proceedings were initiated by under Section 7 by a financial creditor of the Ruchi Soya Industries. My lord, the Section 7 application was admitted by the NCLT Mumbai on 15/12/17. Thereafter, my lords, the IRP was appointed. Thereafter, my lords, COC, creditors of Committee of Creditors was constituted by the IRP, and thereafter, a resolution professional was appointed in accordance with the provisions of the IBC. Thereafter, my lords, the RP, the resolution professional, called for claims from public and from all stakeholders who
Yes,
had.
Mr. Gogoi. Question of law.
My lord. Otherwise, yes, if we go by this point, my lord, then we'll have to adjudicate, my lord. But my lord, the revisional order is appealable order under section.
But if the by operation of law,
My lord.
Yes, my lord.
your right to claim is
My lord. My lord.
extinguished.
Lordship.
Then by the IBC, if you have failed to lodge the claim,
Lordship. Lordship.
it includes state also.
My lord.
It includes state
Yes,
also.
my lord, states, central, everyone, all the authorities.
I will have to examine that part today.
Well,
Otherwise,
keep this order in abeyance.
in advance.
Heard Mr. S. Mitro, learned counsel for the petitioner. And Mr. B. Gogoi. For all,
All.
learned training council, finance and taxation department, government of Assam, for all the respondents. Para. In this writ petition, under Article 226 of the Constitution, common the petition, as I said, the legality, validity, and jurisdiction of an order in revision dated in office of 13/4/2026, passed by the respondent number 2, whereby the revision petition filed by the petitioner has been dismissed and a demand of rupees 8,85743 towards tax and rupees 465,016 towards interest, that is rupees 13,50,759 made by an assessment order dated 17/3/2025 passed by the respondent number 5 for the assessment year 2011-2012 under the Assam Valuated Act 2003 has been affirmed. Close to para. It is the case of the petitioner that a corporate insolvency resolution process within CIRP was initiated under the Insolvency and Bankruptcy Code 2016 against Messrs. Ruchi Soya Industries Limited. And that CIRP has culminated with the approval of the resolution plan by the Committee of Creditors under Section 30 within bracket 6 of the IBC before the National Company Law Tribunal, which was allowed by the NCELT by an order dated 24/7/2019, read with an order dated 4/9/2019. Full stop. Para. The petitioner has stated that no claim was made by the state respondents during the CIRP process. The CIRP during its pendency. And as such, with the approval of the resolution plan, the claim of the state respondents has stood permanently and irrevocably extinguished. So stop. Para. No matter of required consideration, issue notice returnable on so and so. As Mr. Gogoi has appeared and accepted notice on behalf of all the respondents. Formal notice dispatched, extra copy within 2 working days. First of para. Pursuant to the order in revision dated 13/4/2026 6, comma. The proceeding in the form of Bakijai case number 39/15-16 ABAT white certificate number 13503 VAT pursuant to a certificate issued under certificate number 13503 VAT 2015 has been initiated. Full stop. Where having regard to the projection made on behalf of the petitioner and upon perusal of the provisions of the IPC code, more particularly section
30, my lords.
30
sub-clause.
30 thereof, comma, it is ordered in the interim.
I'm sorry, my lord, it's 31. I'm sorry, my
31.
lords, 31.
31 of the IBC, comma, it is ordered in the interim that the operation of the order in revision dated 13/4/2026 and the consequent proceedings of Bakija case number so and so shall remain in abeyance till the return will.
My lords, for the rest of the items, I've prepared a brief authorization with regard to the above. So my lords,
Order
continue.
number was filed. Same order? Year was change over, order revision date is same.
No, my order division is same, my lord, but the assessment amounts are different.
Assessment amount here, synopsis of assessment.
21st August 2108. Item 12.
Twelve is same. Same. 11 is same. 14 is same.
According to count.
11, 12, 14.
Item number 13.
Yes, yes.
Made for the last. My lord, the petitioner applied for permission, my lord, but that has not been.
Petitioner. One petitioner.
By an agreement, if
One to solve whether is known as for selling flat. Flat.
Flat, yes.
Where is your application?
My lord, page 19.
Composite land sale transfer.
Yes, my lord.
Then what happened?
Page 20 is the status report, my lord.
Page
20, Annex 3.
20.
20 and 21, my lord.
28/9/2025.
Yes, last month, 28/9/2025. Forwarded to JS, my lord.
Not yet disposed of. Yes. Sorry, itu niki.
Notice, no. Lordship, I have to take instruction loss.
So within 1 month, you have to dispose of.
Yes, no, as per section 21.
21A. So statutory mandate period is over.
Over, Lordship. Last communication was.
Huh? Procedural is there. I have seen that.
Yes.
Para 7.
Yes.
It still contains a mandate because this is a notification. Notification cannot override section 21A. It is not an amendment to section 21. So we dispose of to pass a either to allow the application or to pass a region order.
Yes.
Expeditiously as possible, but within an outer limit of 1 month.
Lordship.
Heard Mr. G. Uddin. Learned counsel for the petitioner. Miss P.R. Mounto, learned standing counsel. Revenue Department for the respondent number 1 and 2. And Mr. H.K. Hazarika, learned junior government advocate Assam for the respondent number
3 to 7.
7. Post of para. The petitioner has stated that he entered into an agreement for sale with the owner of a flat measuring 646.18 square feet on the first floor of flat. We didn't make it 2 BHK on the first floor of an apartment building located at SK Bhuiya Road, Digholipuguri East Police Station, Lota Hill, Gauhati District, Kamrup Metropolitan District, Gauhati. Subject flat. Post of. The apartment building is on a plot of land covered by DAG number 199/200 and patta number 116, at Revenue Village, Sohar, Gauhati, Part 5, Moja, Ulubari, Gauhati Revenue Circle, Kamrup Metropolitan District, Assam. Post of. It is stated that the proposed seller is a registered owner of the subject flat located in the ground floor of the said apartment building. So agreement in June 2025. So the petitioner stated that after entering into the said agreement for sale of the subject flat and handing over a part of the consideration price agreed to by the parties, he submitted an application on 24/6/2025 for the notified public service, quote, composite land sale transfer, unquote. And the said application was duly received with acknowledgement number NOC stroke for 24 stroke 58535 stroke 2025. Post. While generating the acknowledgement, for the notified public service, to extend the notified public service, it was mentioned that if the application was accepted by the Revenue and Disaster Management Department, the service would be provided within 45 days, within bracket, excluding the time taken to issue the no objection certificate and presentation of sale date before the jurisdictional sub-registrar office, bracket close. And if the service was not delivered within the stipulated period of 45 days, then the petitioner could raise an appeal. Post para. A petition, it is stated that after the application, the Revenue Department made necessary verification and forwarded the application on 24/7/2025 to the circle officer, to the jurisdictional circle officer for a report. Post as per the details uploaded in the designated portal, the application was thereafter forwarded by the circle or jurisdictional circle officer to the additional district commissioner on 15/7/2025. And finally on 30/8/2025, the additional district commissioner forwarded the matter to the district commissioner on 31/8/2025. Post. The district commissioner had in turn jurisdictional forwarded the matter to the Revenue and Disaster Management Department on 28/9/2025 for recommendation, for its recommendation to the special branch. Post. Para. After as after 28/9/2025, no discernible action is found to have been taken by the respondent authorities to process the application for its finality, the petitioner, it is the petitioner stated that as after such, he is constrained to prefer the instant writ petition, seeking inter alia direction to the respondent authorities to process and finalize the application dated 24/6/2025. Post of para. A composite length and transfer ki baat hasil nahi. The Registration Act 1908 came to be amended by the Registration Regime Act Assam Amendment Act 2009, and again by the Registration Regime Act Assam Amendment bracket close Act 2021. Post of. After with the insertion of 2009, with the insertion of section 21A. Post of. After those amendment acts, section 21A of the Registration Act, 2009 reads as under para 3 of that. Composite para. It is a statutory mandate under section 21A of the Registration Act for a jurisdictional deputy commissioner to either issue a no objection certificate containing the description of the immovable property to be transferred, or to pass a speaking order with reasons thereof within a period of 30 days from the date of receipt of the application, in case NOC is not issued within the prescribed period of 30 days. Post of. In a notification dated 9/9/2025 of the Revenue and Disaster Management Department, Government of Assam, a standard operating procedure within bracket SOP has been framed. Para 11 of us. The relevant excerpts of the notification are quoted hereunder. Para. Under section 21 of the Registration Act as amended, and, as well as in SOP formulated by the state government, by the notification dated 9/9/2025, time period of 30 days from the date of application for processing the application has been prescribed. Full stop. But as it is projected that the application, the processing of the application, submitted on 24/6/2025, has not reached its finality till date, despite elapse of more than a year since its submission, and the application is being processed, this said petition is disposed of a direction to the respondent authorities, more particularly, the respondent number 3, District Commissioner, respondent number 3, to bring the entire process to its finality in strict compliance of the statutory mandate contained in Section 21 of the Registration Act and the SOP framed in the notification dated 9/9/2025 within a period of 30 days from today. The application submitted by the petitioner for NOC stroke composite land sale transfer has not been brought to its finality till date. Full stop. If in the processing of the application, any further document is necessary from the applicant, thus petitioner, then the respondent number 3 shall inform the applicant, thus petitioner, in writing as regards such, as regards the deficiency, if any, in the application within a time period of 15 days from the date of submission of a copy of this order at his office. Within a period of 30 days from the date of submission of a copy of this order by at the office of the respondent number 3 by the petition. If the applications are submitted by the petitioner on so and so for NOC stroke composite land sale transfer has not been brought to its finality till date. Right. In such a situation, the time period of 30 days is to be calculated from the date of meeting the deficiency by the petition. Because there is a possibility that they may dismiss your petition that this document is not there. We have seen. So that is why if deficiency is there, you submit it 15 days.
Yes, madam.
Otherwise, you will again come and buy another petition.
Madam.
This order disposes of the petition. So if any deficiency, communicate to him. You will try to meet the deficiency. They have to pass an order, either allowing it or rejecting it. Rejection is by speaking order only.
As part of provision of the law.
Item 16.
Is returnable forfeit as yes.
That matter, that is a fourth round of litigation. On June 2025, we made a complaint. Thereafter, after hearing all the parties, the GMDA passed an order of demolition. Pursuant to that, the CEO passed an order for demolition. There was a date for demolition on 2 March. Firstly, then again on 18/6, they again passed an order for demolition. In the meantime,
due to these developments, we had withdrawn our writ petitions with liberty. Thereafter, the respondents came with a writ petition. Your lordship had relegated to the district court as per 72(2). Thereafter, they moved along with a condonation of delay application, but their stay order was rejected by the district court.
Well, you should notice that. Mr. Bora will be knowing because he is appearing before the appellate authority.
No,
Yes,
no,
what
no,
happened? Stay is rejected.
I have seen the order, my lord. That
Is it order is there?
Yes, lordship.
Appellate authorities?
Yes, yes.
Which
Page
one?
number- Yes, lordship, page number 7. Page number
file in 71.
71.
Okay.
No, there,
No,
Okay, you were there. You were there.
No, lordship, page number 68 is the order rejecting the stay.
Okay, 68. Let us see.
68. Other than mistake.
Yes.
I was there.
Just a minute. Delay condone.
Delay, notice issued on delay. That order is at page 71.
Heard Mr. BP Bora.
But the only thing is that now they are constructing, over and above this, they are constructing shops beside the wall, lordship. Therefore, some stay order is required.
No, how can it be? You get get the appeal dismissed.
No, it is fixed on 20th of August.
But we were agreed by non-execution of the demolition order, right?
Yes. At page 78, lordship, I have annexed the pictures also and the time date, GPS pictures.
Yes, Mr. Bora, again, which paragraph you have stated? That further construction activity?
Yes, lordship, para 21, lordship.
Para 21.
And page 78 is the pictures.
Yes, ensure.
Lordship pass this way.
Heard Mr. BP Bora. Let a counsel put up petitions. Mr. As Bora, and standing counsel.
GMD, my IPF for respond number 2, 3, and 4.
ZMDA for the respond number 2, 3, and 4. Hazarika for 1. Mr. HK Hazarika, Learned Junior Government Pocket Assam for the respond number 1. Where are the petitioners? I propose this court. The agree by in action on the part of the respondent GMD authorities.
Yes,
which is the demolition order?
Yes, demolition order is
Page
59.
15.
Original 1911, Lordship. 1911,
Page.
original 1911, page 38, Lordship. Original order. Thereafter, the
To execute the demolition orders, comma, dated 19/11/2025 and dated 2/3/2026.
2/3/2026 is the consequential order pursuant to demolition. It fix a date for demolition.
Whereby
And 18.
1911, where is the 19/11/2025 order?
Yes, Lordship, page 38.
Whereby the respondent number 3, comma, in exercise of power conferred under section 88 of the GMDA Act 1985, comma, directed the respondent number 5 to 9 to demolish stroke remove the unauthorized construction, comma, mentioned therein, comma, as those unauthorized construction are found to be erected in violation of the approved plan and building bylaws and the GMD Act. Full stop. Next one is
2/3, Lordship.
Page.
Page 45.
By the order dated 2/3/2026. The respondent number 3 had directed to remove demolish the unauthorized constructions of brick boundary wall and house, unauthorized constructions of the respondent number 5 to 9. And a date, comma, 7/3/2026 was scheduled for the demolition. First up. Para.
Then again on 18/6, page 59.
And thereafter, comma, on 18/6/2026. Post up. The petitioners have canvassed that despite the orders, above orders, the respondent number 5 to 9 are still carrying out construction activities
Page 78, Lordship.
in connection with activities which are related to the construction activities which are already adjudged as unauthorized. As on date, as on date. Issue notice. Mr. Dubara, learned standing counsel GMD, has submitted that he needs some time to obtain instructions in a matter. Post up. Mr. Bora, learned counsel, appearing for a petitioner, has submitted that the respondent number 5 to 9 have referred an appeal before the appellate authority under the provisions of the GMD Act, under the provisions of section 71, 72 and 73 of the GMD Act, and a prayer, an application made by that in the state appeal for stay of the demolition order passed by the respondent number 3 has been rejected by an order by the appellate authority on
4/7, Lordship, page 60.
4/7/2026, and therefore there is no bar for the respondent authorities in the GMDA to carry out the demolition orders. Issue notice returnable on PD as so and so has appeared, accepted, no formal notice. Steps upon the respondent number 5 to 9 by speed post 22 working days. Okay. As it is projected, as a statement is made by the petitioners, as a categorical statement is made by the petitioners in paragraph
21, Lordship.
21 of the writ petition, that the respondent number 5 to 9 are continuing with the construction activities on the
Wall.
despite the demolition orders, comma, it is ordered that the respondent authority in the GMDA shall ensure to stop any further construction activities, comma, which are related to constructions already adjudged to be unauthorized in the meantime.
24th August, 2408. Supplementary list, item 46.
May because under the instruction.
No objection certificate.
Yes.
Over telephonic instruction. Lordship.
Over or online, offline?
Well, offline, Lordship. Online
Offline.
is no.
That, my lord.
Only, my lord, that particular area.
Yes, then you have to display hard.
This is just like item number 13,
Yes.
except online and offline.
Hard, Mr. J.M.A. Chaudhary, Learned Counsel for the petitioners. Miss Anne Bordoloi, Learned Standing Counsel, Revenue Department for the respondent number 1, and Mr. J. Hendrik, Learned Junior Government Advocate Assam for the respondent number 225.
25.
Post of. I'll go to Likhayas. Any application number?
Number is.
Okay, it is there. Document 40A.
Yes.
Agor order tour, para 1 to लिख दीजिए.
Second one is.
Just a minute. Both Ms. Bordoloi and Mr. Hendik have submitted that for the area in question, comma, the application for NOC is to be submitted in the offline mode, comma, in view of non-availability of the facility to submit online application. So oral instruction is there?
Lordship.
Here description to not like it's section 21. Bosonta dilu niki. বাগিনী পেয়াৰ তাৰ আগত লিখক the এটা ফেডাৰ তাৰ আগত the petitioner have stated that the petition number 1 to 4 are the owners of where is the land description?
My lord,
Where is the schedule?
schedule of land, my lord, I have annexed the document.
Page 28.
No, you said paragraph 2 that in the schedule land.
Yes.
Where is that?
Schedule is page 28.
Not in the body of the writ petition.
No.
Body of the writ petition, my lord.
Are owners of a plot of land, of a parcel of land covered by DAG number 588 and Patta number 305 located within Moja Rajbari, district Sibhumi, Assam, and in order to sell a part of the said parcel of land measuring 7 kathas, 7 chotoks, 16 gandas, day, and at a consideration of rupees 51 lakh, they entered into an agreement for sale of the said part on 16/1/2026 with the respondent number or petition number,
My lord,
5. First,
5.
5. First of thereafter, the application for the no objection certificate was submitted on 11/2/2026. As the application, said application for NOC has not been processed to its finality despite elapse of more than 5 months since 11/2/2026. The petitioners have approached this court by the instant petition, seeking inter alia direction to the respondent authorities, more particularly, the respondent number 2, to bring the process to its finality within at the earliest. At that, section 21 or same. Huh? What is the other one?
Other one, my lord, scheduling, my lord. This is between
Yeah.
interest. Same, my
Who is the
lord.
owners here?
Owners, my lord.
1 and 2 owner.
1 and 2.
1 to 4 asil to.
And seller, the
What
my lord.
is the total consideration? 42 lakh.
42.
Petition number 3,
Yes.
buyer.
Yes.
Agreement
Agreement annexer 2, my lord.
date 8/4/2026. Application
Application page, my lord. My lord, 11/2, my lord. 11/2/26.
you entered into agreement 8/4 or
My lord, after that, we entered into agreement. After that, my lord, after filing application.
okay. Like any same offline, like any same. A2 agor that was Para 2 agor that was. Same, if any deficiency, 15 days
I'll cooperate.
to be communicated. Otherwise, 1 month. In terms, strictly in terms of that notification, 99/2025 and section 21A. Either to allow or to reject with reasons.
Yes. Okay.
Supplementary list, item 48.
One or three was dictating, due to
Mhm.
paucity of time, could not be finished yesterday.
Just a minute. Mr. Bhattacharya and Mr. Hazarika have responded by submitting that the notices are as per the provisions of the settlement rules from a framed under the Assam Land and Revenue Regulation. And in obeisance of the procedure indicated in the decisions referred to in the notices. Post of para. Settlement rules concern 7. Settlement rules. Post of para. Rule 18 2. Rule 18 of the settlement rules has mention about ejectment. Post of sub rule. Rule 18 to 18. Sorry, sub rule 1. Sub rule 2 of rule 18 has provided that liquidative. Has provided that. Subparas. Sub rule 3 within bracket A has provided for ejectment in all other cases which do not fall under rule 18.2. First of rule 18.3A has prescribed for publication of a notice requiring the occupant to vacate the land specified in a notice, within 15 days of the date of publication of the notice in the manner prescribed, and to remove any buildings, houses, fences or crops, etc., which may have been raised on such land, provided that the deputy commissioner may give time to any particular occupant to harvest the crops, if any, growing on such land. Post of para. On consideration of the provisions of Rule 18, a division bench of this court in Salakuddin, Supra. Which paragraph?
57.
Has drawn a conclusion that the revenue authorities cannot be permitted to unilaterally decide as to whether an occupier stroke possessor has a bona fide claim of right involved in as much as it would require adjudication of both law and facts, and without providing an opportunity to the occupier stroke possessor would be in violation of the principles of natural justice, which in turn would violate Article 14, Article 19 and Article 21 of the Constitution. Full stop. It has been observed that prior notice to the occupier stroke possessor before initiation of proceeding under Rule 18 within bracket 2 of the settlement rules is the mandate of law in order to save 18 within bracket 2 of the settlement rules from being constitutionally invalid on procedural grounds. Post. Where are the division means in Salakudi? Para 63.
Yes, ma'am.
Para 63.
Yes.
Mr. Bhuya?
Yes, yes, no.
As proceeded to
Conclusion
observe
and direction.
as under Para 63. Quote করে দিব। This court, having regard to the observations made in Salakuddin Supra, this court finds no infirmity in issuance of the notices dated 16/6/2026 is concerned. First up, it is submitted by the learned senior counsel in of petitioner that in response to the notices, the petitioners stroke notices have already responded by submitting their individual applications along with all the supporting documents in respect of their claim, more particularly, their the more particularly, the
Victims of 83 disturbance.
more particular, comma, about the permission granted to the petitioners or predecessors in interest of the petitioners to reside in the areas in question, being persons affected in the disturbances during Assam movement in 1983. Full stop. Para. It is relevant to refer to a decision of the Honorable Supreme Court in Abdul Khalik and others versus State of Assam and others. In the Honorable Supreme Court rendered in civil appeal in number the Abdul Khalik and others versus State of Assam and others 2026 INSC 140, which arose out of notices issued by the state respondents to the appellants therein on the premise that the appellants were allegedly residing inside reserve forest areas. Full stop. The Honorable Supreme Court, while finding no infirmity in the process sought to be adopted by the state respondents for removal of encroachment, as the process is found to have conformed to the principles of fairness, reasonable and due process, has observed that has no found. Full stop. Para. In the process placed before the Supreme Court, Honorable Supreme Court, the state government had undertaken that if an unauthorized occupation is found in a reserve area, after scrutiny of the documents, a speaking order shall have to be passed and shall be served on the concerned person, giving him 15 days notice to vacate the unauthorized occupation. And only after expiry of the period of notice, the action shall be taken to remove the unauthorized occupants. Full stop. taking note of the above observations of the Honorable Supreme Court of the Division Bench of this court in Salahuddin and the Honorable Supreme Court in Abdul Khalik, Supra, this court is of the considered view that when after a notice of the nature when a notice is served with a notice alleging unauthorized occupation of any plot of land which is reserved as a reserve forest, PGR, etc. The notice is to be given due opportunity of placing his case before the authority. Full stop. And thereafter, the authority is obligated to give consideration to each of the applications submitted in response to the notice, who are the pleas raised by the applicants in the application therein, and to give consideration to all the documents, if any, submitted along with the application, and thereafter to pass a speaking order as to whether the notice is as regards the status of the noticee, who are the plot of land which is found to be under his occupation. Post. But as Mr. Bhuya has senior counsel appearing for the petition has submitted that the petitioners have already submitted their responses to the notices, and a hearing has already been taken place. This court disposes of the the obligation, the responsibility cast upon the authority to pass a speaking order is to be read, discharged by the authority. In due course, it is only after determining the status of each of the notices, further action, steps, further action as contemplated under the law is to be taken.
My lord, if a speaking order is passed, individual orders, and there the authority holds that they do not have bona fide claim, then that speaking order would construe to be an order issued under 18.2.
That is already Salahuddin is there.
Yes.
We are not doing only in accordance with law. Everything is laid down. Why it should be repeated?
Fine.
You know, he knows.
Fine.
You know, he knows everything, the procedure. So we'll not go into the merit of the claim. Just we have read into it that a speaking order is to be
Yes, and communicate.
and the speaking order so passed is to be communicated to each of the petitioners
Yes.
immediately thereafter.
But the individual speaking order is required.
Yes, I have
Yes.
said individual speaking order.
Yes, yes. Oblige.
We'll make the correction.
Oblige.
49.
Anything further is to be required.
Here. No.
Oh, that Jakpal Singh.
Jakpal Singh, my lord, and only.
One line, Mazot eta para. The law regarding common village land, stroke community land, like VGR, stroke PGR, has been well settled by the decision of the Honorable Supreme Court in Jakpal Singh and others versus State of Punjab and others, 2011.
Only exception is that if it is the land is used for public utility purposes.
Well settled. I have said I will not repeat it. 2011, 11 SSC 396. And the same is not required to be adverted to. Not required to be adverted to. It is already there. Why should I repeat? Only reference, since it is in the reference notice.
Obliged, deeply obliged.
Disorder disposal of the repetition.
Item 49.
Yes.
The petitioners agree with my illegal detention of his vehicle, my lord, by the police authorities, my lord. What happened, my lord? On 4/7/2026, my lord.
4/7?
2026, my lord. 3 vehicles were detained by the police authorities, my lord.
Police.
Police. And when the petitioner inquired about, they said, my lord, they have referred the matter to forest.
Where is that? Where is that?
So everything was done verbally, my lord.
Okay.
Thereafter, my
No,
lord,
no, seizure, no seizure.
nothing, my lord. And just listen the facts, my lord.
4/7, what
4/7,
happened?
3 vehicles were seized detained by the police authorities. When the petitioner made a query the reason for detention, they said they have referred the matter to the forest. Petitioner visited forest officers, they said they referred the matter to GST authorities. Petitioner visited GST authority, they said they have not received any formal communication. Then, my lord, on 8/7, petitioner lodged a complaint that the lordship will find at page 26. The complaint was lodged by the petitioner.
Before officer in charge.
So the respondent was detained, my lord.
Ah.
This copy was endorsed to higher authorities. The moment this complaint was lodged, my lord, the forest authorities has issued a memo that lordship will find it page 30, saying that there was minor discrepancy in the weight of the vehicles. And verbally they asked us to make payment of rupees 17,000 under GST. There is no order, my lord. We made a payment, my lord. And they asked us to make a payment of GST of 17,000. At the lordship will find it page 31. We made a payment, my lord. Otherwise, they don't have the authorities. However, we paid it, my lord. After making payment, my lord, when we went for releasing the vehicle, the officer in charge is saying you withdraw the complaint, my lord. Then only we will release the vehicle. We also withdrawn the complaint. The lordship will find it page 33. The vehicle, after withdrawing the complaint, my lord, the vehicle was released. Thereafter, my lord, again, my lord, on 15.
Page 33.
33 is the withdrawal letter, my lord.
Okay.
After withdrawing this complaint, my lord, vehicles were released, my lord. Thereafter, my lord, on again, my lord, 15/7/2026, my lord, another vehicle was again detained by the police, my lord, without issuing any order or any, my lord, notice, anything, my lord. The vehicle is still lying in this police station, my lord. Since 15/7, my lord, I have made a statement, my lord. The lordship will find it page 14 and 15, my lord. Paragraph 14 and 15, page 11.
Okay.
This vehicle is still lying there, my lord. There is no.
Yes, who is for respondent number 5? Yes. So 3, 4, and 5.
Yes, boss. One also.
No, they are answerable. We will not bring respondent number 1 as on date. But 3, 4, and 5, this 5 is in charge. 4 is officer in charge.
In charge of.
3 is superintendent of police. So they are answerable. Yes, what do you want to say?
Well, I am for the forest department, 6 and 7. 6 and 7.
Now, as on date, it is respondent number 5. Who else?
Yes, madam.
Third, Mr. R.S. Mishra, learned counsel for the petition. You take instruction under what provision? Petitioner. Sir H.K. Hazarika, learned junior government advocate Assam for the respondent number 1, 2, 3, 4, 5. And Mr.
Ash Sharma.
Ash Sharma, learned standing counsel. Forest Department for the respondent number 6, 7, 8. And GST, Mr. B. Chaudhary, learned standing counsel. Finance and Taxation Department, Government of Assam for the respondent number 9 and 10. It is the case of the petitioner that in a regular course of business, the petitioner dispatched a consignment of green core and allied products from its unit at TIZIT, Nagaland to Lakshmi Timber Industries, Coach Bihar, West Bengal, white tax invoice number IN 13070000700, dated 13/7/2026, para 14. Posto. But like in a previous occasion, the respondent number 5 has again detained the said consignment along with vehicle bearing registration number AS-17/C-9090 on 15/7/2026 without any documents, without any seizure memo. Post up. The detention, it is stated that the detention is made when the consignment was in transit with valid documents. Para. Mr. Hazarika, learned counsel, junior government Assam, has to obtain instruction about the region for detention of the vehicle and the consignment. Post up. Release the case on 1 week to next day. To enable Mr. Hazarika to place the instruction.
Pendency shall not be barred if they wish to release them and release the vehicle, my lord, if courtesy permits.
31st July, 3107.
Find out.
For impeachment, item number 17.
Please, Lordship, here we have sent to file for filing affidavit, we have sent for waiting and signing. So Lordship may kindly grant us sometimes.
Yes, something was said on the previous date. What was said?
Your Lordship, remember.
We deferred consideration of IA.
Yes.
What is the reason?
My lord, the issue was that on the last occasion, because we came up before this honorable court saying that we have a patta land, and based on that patta land, the PWD is planning to construct a road. So notice was issued. And on the last occasion, the learned senior government advocate he stated that he have received an instruction where it is stated they are not contemplating to conduct any road. So on that grounds, your Lordship directed you file the affidavit, and in the meantime, if that on that ground can be disposed on, there is no question of getting any improvement.
Right, the petitioner, if the petitioner has no cause of action
Yes, then there
to
is no,
proceed, then you don't have any.
yes.
So,
Not being constructed.
huh?
If road is not being constructed.
Right, then you do not have any cause of action.
Yes.
And he has also not cause of action.
When Mr. 1 week, sure.
Lordship.
Okay. I go to repeat Kodiwa AM Borovia, applicant in IA, K. Mohammed, petitioner in WBC, and Mr.
R. Sahana on behalf of
R.
Dinat.
Saha,
On behalf of Dinat, Lordship.
on behalf of Mr. D. Nat, Lion Standing Council PWD for the state respondents. Post of Mr. So Land Council has submitted that the draft affidavit has already been sent for vetting
Lordship.
and has prayed for. No, with has submission, that the draft counter affidavit has already been sent for vetting. Has sought listing of the case after 1 week, as the said counter affidavit will be filed within 1 week's time. First of, as the counter affidavit on behalf of the state respondent is going to be filed within a week's time, list the case in the same column on
3rd August 0308.
I love Lordship.
For admission, item number 19.
There is an interim order, it will come.
or the interim order. Past the shall continue.
Obliged.
Yes.
May please, your lordship. My lord, here, my lord, my gun license has been revoked, and I have challenged the order by which my gun license has been
After
revoked.
appellate authority.
Yes, my lord. Initially, it was
Reading
fine.
complete. Reading
Reading
complete.
Complete, my lord.
Let it be on a hearing date then.
My lord.
M.A.I. Hussain. Petitioner. Mr. Taluga, here for all. Mr. B.J. Taluga, Senior Counsel, estate by Mr. P.K. Medil, Learned Counsel for all the respondents. Heard. The Learned Counsel for the parties have submitted that exchange of bidding is complete. And the requisition can be taken up for final consideration. As in view of the above, let the case be listed in the admission column on so and so.
2008, 20th August.
Hello.
Item number 22.
May it please, your lordship. The son of the petitioner was an accused in this case, your lordship. Subsequently, the petitioner's residence was demolished, your lordship. The authorities had not given me any notice. In fact, they have admitted in their affidavit in opposition, the counter affidavit, that they have only done miking. Your lordship may kindly peruse their counter affidavit for a moment at page 36. Paragraph number 4.
Demolished. You have been evicted or what?
Yes, I have been evicted, your lordship. My residence has been broken down. It was a Assam type house, your lordship, with 7 rooms. My grievance, your lordship, is that no notice was given to me.
No notice?
No notice was provided to me. So may kindly peruse page 36 for a moment with the counter affidavit. Paragraph number 4. According to them, I was in a government. May I read your lordship?
tribal belt area.
Yes, Your Lordship.
So what is the consequence?
Your Lordship, in this case, what we have,
What relief can be extended?
some compensation at least may be given to me.
So there are so many demolition cases before the Supreme Court. What law has been laid down?
Some amount of compensation or at least
What
some
law?
resettlement. Yes, Your Lordship. I'm relying on the law.
Let us have those.
Yes, the Olga Tellis, I'm relying on Olga Tellis.
Olga Telly, no, recent many cases now.
Yes, Your Lordship.
Recent many cases. This bulldozer.
Bulldozer is also.
UP.
Yes, Your Lordship.
Olga Telly has gone
Yes.
long back. What are the new?
On the
Honorable Justice Gauhati, Honorable Justice Chandrachud, they have delivered few judgments. Where are those? Yes, Mr. Talukdar.
They were evicted
Oh,
by
this is
the,
very
there was
difficult,
some
very
hearing.
difficult to read. I find very difficult to read all very small letters. Better to have neutral citation. This is very difficult to read.
I understand.
Look at this judgment, re-demolition. And there are others also, by Justice Padiwala also.
Yes, sir.
Where are those? Don't keep it inside the brief.
Padiwala's husband, I think I do not have. Right.
Huh? Justice Chandrachud also perhaps.
Yes, sir.
Okay, I will try to get it, neutral citation. He has anything to say that is without notice?
Without notice, but some sort of hearing was there and they were found to be not within the protected class. My lord, therefore.
Protected class.
Notice
but,
part is different. My lord.
Tribal belt. Tribal belt or VGR or reserve forest.
Notice.
But notice and hearing
My lord.
is required.
Notice was not there, but hearing was there.
Not it appears to be falling within the bulldozer
Maybe.
principle. Just because he is an accused. UP. Okay, we'll consider next week. Let me go through it.
Definitely.
And what kind of, do you have any evidence regarding the quantum?
No, Your Lordship.
What kind of one katha?
One katha 7 lesson.
7 lessa. And what is the description of your
Assam type
house?
Your Lordship.
Where you have stated?
In my representation, I have given it, Your Lordship.
30 lakh is not possible.
No.
30 lakh is not possible.
In my representation.
It is a token, thing reserving the liberty to lead evidence.
Yes.
Which one?
And in my representation in the
In the writ petition, where have you stated? What kind of dwelling house you had?
paragraph page 31, Your Lordship.
No, in the body of the writ petition.
Body of the writ petition, Your Lordship.
Or a statement on vote. Where is that? 7 room.
7 room. Assam type house, 7 room. Page, paragraph.
Let us see your land revenue received.
There is an agreement, Your Lordship. There is no land revenue received, Your Lordship. Page 28, Your Lordship.
These are photographs.
These are photographs also.
Any photograph prior to demolition? Any photograph?
No, Your Lordship, we have not annexed it.
Page 23.
Yes,
Is it the house?
Yes, Your Lordship. This is demolished.
Which one
house,
is
sir.
the house?
Demolished house. With all demolition, Your Lordship. These are the photographs of
Right.
demolition. From paragraph page 19 onwards, Your Lordship. The house has been demolished. Page 23, as Your Lordship has pointed out, is the demolished roof.
Page 20, the house behind the bulldozer.
Yes, Your Lordship.
Huh?
Yes, your lordship.
No, I'm trying to look up where, but these are
Tin roof.
Tin roof
not
house, your
tin
lordship.
roof,
Assam
but
type house, your lordship.
huh?
Assam type house, your lordship. Tin roof.
Tin roof, but here concrete post with bamboo walls. Nothing concrete.
All bamboo. No, your lordship, it was concrete.
Tin roof.
Tin.
And page 23 does not look like it is a 7-room house.
There was a concrete wall, your lordship.
Where are the signs of concrete?
Page 25, your lordship, may kindly peruse for a moment.
This looks like a school. This looks like a school.
No, no, I've been told this is a part of the house, your lordship. The front part of the house, no?
Hmm. Yes, what kind of, Mr. Taludar, what kind of instruction you have regarding the house?
Such time not have, my lord, but there are two persons. One has taken away all the belongings, only the structure, but not the petitioner, the other person. And this doesn't appear to be a bulldozer. This must be a tractor.
JCB?
May not be, my lord. This may be a tractor only because page 24.
No, it is akin
For
to
carrying
bulldozer
a-
action.
Or
It
maybe
is
for carrying-
akin to bulldozer action, what the
But-
Supreme Court has now termed bulldozer action.
My lord.
All those decisions, they have said termed, the coin is termed as bulldozer action. So it is looking like that. Action is like bulldozer action. But what instruction you have regarding the
Structure, I did not.
structure?
That I did not, we have not said anything in our video.
Oh, I'll just, in the absence of any instruction, we'll go by our own
Fine.
intuition. Heard Mr. T. Deori, Learned Counsel for the petitioner. And to लिखा ना? Mr. B.J. Taludar, Learned Senior Counsel.
Only one line is there, my lord.
Page?
Page 34. The read petitioner was occupying a plot of land measuring 1 katha 7 lesa with
Which
katha
paragraph?
structure.
Which paragraph?
3, paragraph 3. Last part of paragraph.
If your lordship may kindly allow your lordship. There is an inquiry report at page 40, your lordship.
40.
40. And it says it's a kacha structure house, your lordship.
From the, that is what I am saying.
I have, your
It does not like it is a concrete structure, tin roof,
tin roof,
bamboo, walls.
walls. Page 40, your
Page?
Page 40. The second fact finding, your lordship, second fact finding paragraph.
Okay.
Infill, Hanif Ali.
Paragraph. Okay, kacha structure.
Pakka structure house at the dark number so and so in Sangeeta Rai. Says Pakka structure. Hanif Ali is Pakka structure, the other one is Kacha structure.
Other one is Pakka.
So the Hanif Ali, the petitioner is Pakka, your lordship. Sangeeta Rai is Kacha, your lordship. There was another.
Hanif Ali with kacha?
No, Hanif Ali is Pakka. Infill, Hanif Ali occupying the area of so and so Kacha structure house of dark number so and so. Oh, yes, your lordship. With Pakka structure.
Kacha?
Yes, your lordship.
Not Pakka.
Kacha.
Okay. As agreed to, as software and agreed to by the learning council of parties. You do not want to file any response?
No, your lordship.
The learned,
No, we have already filed a response, your lordship.
Huh?
We have already filed a response.
Okay.
The region register.
No. No, a reply has been filed.
Which file did you also?
Not on record.
Oh,
That I don't know.
We find it, Your Lordship.
Let us see, let us see.
No copy. No.
No, nothing.
It is there, Your Lordship. I have to serve the opinions.
Mr. Deori has submitted that an affidavit in reply
Yes, Your Lordship.
has already been filed on behalf of the petitioner. On behalf of the petitioner has already been filed. And the said affidavit in reply is not on record. This is the case on so and so. With the affidavit in reply, comma stated to have been filed already by the petitioner, come on record. Next week, reading. Yeah, normal. We'll try.
I'm very grateful, Your Lordship. 31st July.
Okay, Mr. Deori, just a minute. Yes.
7th August 0708.
Very grateful.
Item 27.
May it please, Your Lordship. The arguing counsel is on legs, Your Lordship.
Lordship, in this case, we filed the affidavit yesterday. That has not come on record.
No, he has called it wrongly. It is item 25.
25. Item 25.
You are there?
That Lordship, land acquisition matter, Lordship is directed to measure the actual area of the land presently the petitioner under possession. The petitioner is claiming to have possessed the land under Doc number 777 and 789 of Pota number 102. And they have claimed that I am encroached over the government land and I unauthorized.
My order is clear.
Yes. Lordship,
Para 6 and 7.
Lordship.
To carry out an exercise to measure the actual area of land presently under possession of the petitioner.
Lordship.
Right?
Yes.
Now,
They have carried out, they have submitted a report before this honorable court, Lordship. They have measured the unauthorized occupation.
that is not,
That was not the intention of this honorable court, Lordship.
where is that?
That the affidavit in opposition, Lordship, page 106.
Order dated 26, 21/5. Yes, Mr. Hazarika.
Lordship,
What you have done?
Lordship, have a look, page number 107, Lordship, in our affidavit.
107.
Yes, Lordship, affidavit filed by the.
Filed by? Filed by respondent number 4
Lordship.
in compliance of order dated 21/5/2026.
Lordship. Lordship,
That is in page 140 here.
Yes, Lordship, in point number 2.
Point number 2.
The actual area under the unauthorized possession of the petitioner as reflected in table number so and so is.
That is not the query. That is not the query of the court.
Lordship.
Query of the court is that the actual area of land presently under possession of the
Petitioner.
petitioner. Because Doc number 777, 789, he has 2 plots of land. So court observes that the petitioner can have a valid claim of title and towards possession of the land under the said 2 Doc number only. And beyond such plots of land, if any land is in occupation of the petitioner, the same would primarily amount to be in unauthorized occupation. So I asked you to measure the entire area of land presently under occupation of the petitioner. Whether your structure has been demolished.
No, Lordship, till done.
Is it there?
Yes.
But what is the finding? That land.
All under 808, which is a government land.
And that is not under National Highway.
Yes, not National Highway. It is
And where is the notice?
That notice. Lordship would-
Oh, your house is in existence.
Yes, Lordship.
Now, what is the categorical finding? And stand of the respondents
Lordship.
that NHIDCL
Lordship.
has said that 808 is not acquired.
No, 808 is a government land, it was acquired, but as per Lordship,
No.
3A and 3B.
808. Whether it is,
That is government land.
it is acquired or
Not
not
acquired.
acquired?
Lordship, 80
Not
land of the
acquired.
petitioners, he is claiming Lordship.
No,
his land is
808, 8082 is there.
808, just say 808 is acquired
No,
or not.
not 58 Lordship.
Because
Lordship, that
land is a state subject.
yes, Lordship, that 808 is acquired and that is
Where is that?
government land.
Where is that?
Page 58 is a notification Lordship. There is no mention of 808 tag number. It was
That
my,
is what I am asking.
yes. That was my case also.
Because government land is also acquired, like
Has to
say
get right.
690.
Lordship. 690,
Yes.
yes. That was my argument on earlier occasion.
Lordship, kindly peruse my affidavit in opposition, Lordship, paragraph 10, Lordship.
Page,
Page 108, Lordship.
paragraph?
Paragraph, Lordship, 10, Lordship.
Whether under 3A or 3D, tag number 808 or a part of tag number 808 has been acquired or not.
Lordship is asking that in the 3A or 3D that number
Yes.
808 is reflected or not, if that is.
Not reflected.
Because government land is also to be acquired.
Yes, Lordship.
Come to page 58. Come to page 58.
Yes, Lordship.
Moish Khuli Para.
Yes, Lordship.
Moish Khuli Para.
Yes.
See tag number, serial number 117.
Yes.
690.
Yes, that is government.
Government land.
Yes.
It is to be acquired
Yes.
because land belongs to state,
Yes, Lordship.
government land. Now, after acquisition, land belongs to state government. Oh, sorry,
Central government.
Central
Lordship.
government.
Vested exclusively in the central government, free of all encumbrances.
Yes, Lordship.
So, government land is to be acquired also.
Yes.
So, where is 808?
Lordship, in this case, Lordship, he is claiming that his DAG number 777 and 789 is acquired, Lordship.
Mr. Talura, the question is page 82.
Yes, Lordship.
Question is page 82.
Yes, Lordship.
And for that purpose,
Yes.
whether 808 now belongs to central government or state government. Right?
Yes, Lordship.
If 808 does not belong to state government,
Yes.
then no notice under section 26 of the Control of Highways Act is maintainable.
Lordship.
Right? Second, unless, because, okay, this notice is by general manager.
Lordship.
So this may go. Holy, it is your case now. According to you, it is still a
Government.
government land. Not central government land, state government. Then if he is to be evicted, then it is under Rule 18.
Lordship.
Not under this. I thought that this has been issued by circle officer.
No, Lordship.
Okay, he may be highway administration.
Lordship. Administration.
He can issue, but
Provided
provided
land is acquired.
808 is
Acquired.
under national highway. Very simple now.
And it should be included in the notification also, Lordship.
Yes, then only I will get something. That's not my case, Lordship.
So otherwise, duty to evict him lies on the central government, not on highway administration. Have you understood your case?
Yes, Lordship. Yes,
It is your own stand now.
yes.
Para 10. You have not been able to show from 3A, 3D that 808 has been equal. You are enjoying interim order?
Lordship.
Good. If time permits, tomorrow.
Lordship, tomorrow, Lordship.
Lordship.
Right.
Because, Lordship, we have also urgency, Lordship. Due to this situation, some work has been stopped.
This has to go. Prima facie. 80% is tilted against you now.
Lordship.
Unless you rebut it. Bringing some notification under National Highway Act before the court. Do the exercise, whether 808 is in any of the notifications.
Notification or not.
Heart PP Dr. Petitioner, RK Talukdar, NHIDCL 1678. Aforesaid. Yes, Mr. Aforesaid, what do you say? What do you say?
It is the state government land. Then that authority cannot issue. Once acquired by central government, then it exercises power.
No, thereafter, not that prolonged procedure 18 to notice, immediate demolish with bulldozer. Aforesaid is Standing Council Revenue 2, HK Hazarika 34M5. Come ready.
Lordship.
As the pleading is complete, raise the case tomorrow. Subject to, because one more case is there.
Yes, yes, sir.
Item number 1, right? Huh? Additional Solicitor General of India is supposed to come
Oh,
from Supreme Court.
Lordship.
So if that happens, your case will be deferred.
Lordship. Mehta.
I don't know who is coming.
It will be our
Or who
privilege
is supposed to come, I don't know.
to witness the proceedings. Of like.
Okay, okay.
Item 26.
Yes, Mr. Mozumdar.
Lordship is made to the ex parte award of a permanent look adalat, Lordship. Earlier, Lordship, this honorable court also.
Any subsequent development?
Lordship,
You have brought it.
Lordship,
Subsequent development, you have brought it by affidavit.
Lordship, subsequent development I wrote. Lordship, because
I don't know what subsequent development will it.
You have not got the affidavit.
I pray Lordship any other day, any hearing day, Lordship, subject to convenience.
Okay. You are enjoying interim order.
Lordship.
Okay.
with all the-
Yes, Mr. Siga.
Yes, my lord, any other day.
Sign over.
My lord, here in
15
this
of
case, my lord, they are saying ex parte order. Earlier occasion, they are also on ex parte order. Their court has directed to appear, they appeared, filed WS, then again absent.
Lordship.
Okay.
by
What
fall-
can be, my lord?
We will not look into now. Mr. K. Mozumdar, petitioner, A.R. Sigdar. For whom? All,
Private respondent, all the private respondent.
for all the respondents are present. Okay. Let Standing Council Assam State Legal Services Authority
Yes, my
be
lord.
there.
Yes, my lord.
I should have solved the copy also.
Having regard to the court is impleading. Court is impleading.
My lord.
Just you file an amended cost,
Lordship, is- I will-
amended cost settle by
Lordship,
day
I
after
will-
tomorrow.
Lordship,
Having regard to having heard the learned counsel for the parties, from our court is of the considered view that will not impede the presence of the Land Standing Council, Assam State Legal Services Authority is necessary to render assistance to the court.
Lordship.
First off, Mr. Mojumdar, Learned Counsel for the petitioner, shall serve a copy of the writ petition and other pleadings to the Learned Standing Council, ASLSA, by tomorrow.
Lordship.
Post op, as sought for and agreed to by the Learned Counsel for the parties, list the case on so and so on a hearing date.
20/08,
The
20th
name of
August.
Learned Standing Council, Assam State
Legal Services Authority.
কি কইলে short form to দিব, is to be reflected in the respondent side the contest. The interim order passed area shall continue.
My lord,
till-
I pray that the matter may be
No, all are
not
lined
on
up.
20th August, but after 22nd August, my lord. After 22nd August.
25th, 25/08.
Obliged.
March.
You serve a copy
Lordship, by tomorrow, Lordship, I will make.
because both are private parties
Lordship,
here.
Lordship, I have no objection, Lordship, because they have not
So
followed. the law.
let a neutral person be there.
Surely. But I also, Lordship, what case is there, Lordship, if law is permitting, Lordship, because they have not properly,
Okay.
it's good, Lordship.
Item 27.
Lordship, we have filed an affidavit that has not come on record. Let it come next week along with our affidavit, Lordship.
A Trial Learned Counsel of the petitioner is present. Mr. B. Chogravi, Learned Central Government Counsel for the respond number 1 to 4. Who is there? State Counsel? N. Goswami, Learned Junior Government Advocate, Assam for the respond number 5 to 7 are present. Mr. B. Chogravi, Learned Central Government Counsel for the respond number 1 to 4 has submitted that
Yesterday only.
an affidavit in opposition on behalf of the state respondent has been filed yesterday, and the state affidavit is not on record. First up, as the affidavit in opposition of the respondent number 1 to 4, stated to have been filed yesterday, is not on record. Let the case be listed on. This is July, right? 3rd of August. No, not 3rd, not 3rd. I'm sorry. 3rd of August. With the same on record. Already continued.
Lordship.
Item number 28.
Madam, in spite of this Paktalan, madam, the process by taking self permission in India 98. Your Lordship already passed one order, madam, there's been an order. Already it was some publication of one notification, but wrongly, that has been set aside. In the year 99, wrongly, madam, their madam Paktalan become cast time, madam. Subsequently, your Lordship already passed order. They have also annexed here, madam. But subsequently, madam, when we took permission, madam, if to avail
So you became the patta holder.
Yes, madam.
Right. Then what happened?
Thereafter, madam, what is happened, madam, your Lordship, this one.
Rejection report. Then
Yes,
what happened?
We wanted to obtain the sale permission, my lord. First one,
Okay, NOC.
NOC, my lord.
Okay.
That was rejected by the circle officer saying that they have not.
Let us see rejection report.
My lord, they have Annexus C.
Annexer C. Page.
Just there in their affidavit in opposition, they have stated in different way, my lord.
No. Have you annexed that rejection order?
In my application, it is.
How it is there? Annexer 3. Let us see Annexer 3.
Annexer 3.
You said Annexer 3.
Yes.
Rejected the application.
Yes, Annexer 3. Compose service name applicant and rejected, my lord. Page 19.
Page 19.
Page 19. CO has rejected the application up to date land revenue receipt, up to date land revenue receipt. That was not enclosed.
This is an appealable order.
Already, my lord, correct. In spite of that, circle officer rejected my lord prayer. Again, I applied for. subsequently, annexure 4. Annexure 4, second time applied for, but kept pending in this way, my lord. Saying that land is wetland now, my lord. India affidavit.
Wetland.
Wetland.
Where is it?
That is, my lord, India affidavit.
Just a minute, just a minute. So, when you came before the court,
Yes.
after annexure 4 application
Yes, my lord.
or rejection,
My lord, immediately after the annexure, my lord,
after filing that application, when the application is kept pending,
now after
second application
second application
kept pending,
pending, my lord.
then you came.
Yes, my lord.
Okay.
Annexure 7, page 25, my lord. In my writ petition, can you peruse your lordship? Everything they have. Petitioner has
I'm
mentioned.
writing this so and so, so and so.
Petitioner submitted representation. That, sir, I applied for a land parcel permission, filed NOC dated 19/9/24, but the application was rejected by the circle officer due to non-submission of the up-to-date land receipt.
Now, what is the stand here?
Yes, madam. They have filed affidavit in opposition, and one cryptic report has been mentioned by the
Which paragraph? Let us see.
6, Lordship.
Paragraph.
Paragraph 6 in our affidavit in opposition also.
relevant, yes, page 8. Relevant paragraph 8. How can it be, my lord?
1 minute. Directed, certain. So mutation was done.
Yeah, it was earlier also 98.
No, no, when after this
Yes,
judgment.
mutation done. They have also annexed here.
No, no, please take us to that.
Yes, my lord. Annexus C,
Annex page.
page, my lord, 41.
Their affidavit.
Page 41.
Their affidavit.
In their affidavit and my affidavit, my writ petition also it is there.
The judgment was when 1/4/2024.
Judgment was
Issued by
1/4/24.
the Senate as per the said comprising so and so is carved out of the মেয়াদি পট্টা খেৰাজ মেয়াদি পট্টা ভুক্ত কৰা হ'ল। Your English translation is not totally complete. Your English translation is there.
Yeah.
Where is your translation? That mutation order?
Page 30.
Page 13. So this order has been passed. Land record has been corrected.
Corrected, madam.
Now it is a plot of land patta is issued.
Yes.
In your name.
In Sita copy also they have annexed. it is mentioned in Assamese ballot, আমাৰ মাধ্যমে উল্লেখ কৰা অনুসৰি উক্ত ডাগৰ ভূমি শ্ৰেণী তৃতীয় শ্ৰেণীৰ পৰা বাসস্থান থাৰ্ড শ্ৰেণীলৈ নাম নামাকৰণ হল আৰু ৰেকৰ্ড ব্যৱহাৰ তৃতীয় শ্ৰেণীৰ বাৰী হিচাপে গণ্য কৰা হয়। English translation, page 43, Annexure D, India. Item number so and so, 923. The aforesaid plot of land was classified as scheduled residential 3, and in record, it should be treated as residential 3. It was before the order, my lord, as it is written. 7/9/23.
21, it was some. What is paragraph 7, Mr. Hazarika? In your repetition?
In our affidavit in opposition.
Please read.
With regard to the.
First you read 6.
6. With regards to the statement made in paragraph number so and so of the writ petition, the answering deponent begs to state that the scheduled plot of land is wetland.
Let us see 13/10/2025 letter. Annexure B.
Annexure E.
A note, hurry to. Amendment. Wherefrom you are saying it is wetland? What is the basis?
Lordship.
Secondly, in letter 13/10/2025, another ground, zonal value rate not found, popping up while processing the application. So zonal rate value is not available. That is perhaps is another ground. So suppose a person wants to sell his plot of land because say his father or mother is about to die due to cancer and money is needed for cancer.
It is true, Lordship.
Zonal rate value not popping up in the computer. So it is delayed for 1 year. Is it such ground is open? Don't open, I think. It is not open. Secondly, wherefrom we are saying wetland. If somebody is, whether there is any bar, whether it comes under that Wetland Act. There is Wetland Act, Horu Bill, Horu Hojai, or what?
Assam Urban Area.
Borsola, something like that.
Earlier it was Gauhati Wetland Preservation. There's another one.
Assam Urban Water
Urban Water Bodies
Preservation
Preservation and Conservation Act 2024.
Whether it is notified or not, I'm not sure. But if it is notified, then there would be a bar. Where I've checked.
No,
There is one.
where from he is saying, Mr.
Section 14.
See the
Yes,
Sita copy.
Hmm.
Sita copy at page 41, Bahosthan. If he wants to, the seller or purchaser wants to stay in Venice, let him stay in Venice, but it is still a residential category. Have you seen Nir Mahal in Tripura? The palace by the Tripura king. It was inside a pond, in the middle of the pond.
I have seen Jalma.
Or Udaipur.
Yes.
If they want to stay, let them stay. It is residential class. Where from he is saying? In any view of the matter, it is the district commission under section 221A who has to pass the NOC.
Yes.
He may have reported. Circle officer is not authorized. Under section 21A amendment, it is only the district commissioner.
Yes.
That power cannot be delegated. So he has to pass an order. Whatever is the report of the circle officer,
Yes.
he has to examine,
Yes.
pass an order.
Yes. Earlier also, my lord, instead of cancelling their rejecting the prayer, my lord. they have
Okay,
to
let me try,
provide
let the other orders, let the other matters be called. Thereafter, we'll try to dictate your case.
Item 29.
Yes.
Payment of compensation for the acquisition of the land and the residential building standing there on Malo.
Your land have been acquired. Just a minute.
Mm. 21. There is an interim court of Malot at the time of issuing the notice of motion Malot. This restaurant was directed for making payment of this compensation amount Malot as assessed by the competent authority Malot. Then we measuring 1 kata 17 lasers covered by the number so of Malot was equipped Malot along with the residential house belonging to the petitioner Malot. But initially their assessment was made Malot. That assessment Malot, that was initially it was assessed at rupees 6,67,428 Malot. But that was not sufficient Malot. That was not properly assessed by the competent authority Malot, for which an expenditure was made Malot. And pursuant to the expenditure made by the petitioner, a executive engineer by PWD Malot, that I will take to lordship. So, page 29 Malot.
Page
29.
Just let me read it.
Page 24, no? And 20. This is the annex of 2 Malot. That is the first notice Malot. Notice was initially issued to the mother of the petitioner Malot.
Page?
Page 23 Malot. It's a typed copy. It is the serial number 5 Malo, a page schedule of the Malo schedule. Girat amount 13,34,852 Malo.
So this was a notice.
Notice Malo.
By competent authority.
By the competent authority Malo.
This is a 3E notice.
Well.
Okay, 3E notice.
Well.
13 lakh.
13 lakhs, 34,852, my lord.
Zirat.
Jirat, my lord.
Then what happened thereafter? Did you receive it?
No, my lord. As against that, my lord, so we submitted this representation before the Deputy Commissioner Malakam Group, that you lordship will find at page 20.
Because this, yes, because this notice, if you see at page 24, this notice is under section E.
Well,
3E. Where is your name at page 29? Okay. This PWD engineer assessed another amount of 18 lakh plus.
That is by person to our representation, my lord.
Right.
That especially it was mentioned there to oversight, my lord, the proper assessment was not made initially, my lord. That has been stated in that letter, my lord. The Annexure 5, page 29. With reference to the subject, may I read, my lord?
So thereafter, additional deputy commissioner forwarded the matter to general manager NHIDCL. Page 37. Right? Now, who has filed the affidavit?
By the respondent number 7.
Let us read his affidavit.
Paragraph number 6, 5, 5, 6, and 9.
When did you prefer that application? For reconsideration?
There is
29/9/2023.
13/12.
3G award was approved and deposited for disbursement.
You can get here.
8/11.
8/11/23.
And then next annexure formula page 27. It is subsequently second representation was made, my lord, on 13/12/2023, my lord.
Any NHIDCL affidavit?
No, not filed. We have not filed.
Mr. Das. From the affidavit of the respondent number 7, paragraph 5.
5, 6, and 9.
No, I have read paragraph 5. I cannot read all the paragraph together. Paragraph 5, last line, 3G award was approved by NHIDCL and compensation was deposited with Kala on 11/9/2023 with disbursement under section 3H of the NH Act. 3H means it is to be deposited with Kala. Then responsibility of the acquiring authority ends. Thereafter, 3E notice is to be served, and where giving 60 days period, one is to be asked to receive the amount. Now, paragraph 6. although received dated 8/11/2023 of representation, dated nil. You have submitted a representation for reassessment.
Yes, sir.
Right. Now, competent authority Kala,
Right.
land acquisition, that is respondent number 7,
Yeah.
has lost his jurisdiction to decide on any reassessment.
Right.
Only option available to the petitioner based on all these reports of PWD engineer is under 3Z5 of the National Highway Act. Only the arbitrator can enhance the value of surface compensation or Jirat compensation, because Kala is not now empowered, as he has rightly said in his affidavit, that I am not empowered now. After 3Z1, it is the arbitrator. Let us see.
3G, sir. 3G. PG, my lord, determination of amount payable as compensation.
Yes, where any land is acquired.
Under this act. Under this act, there shall be paid an amount which shall be determined by an order of the competent authority.
That is, he said 11/9/2023. Then 3, subsection 3. That is notice.
Right.
Then
Public, that is public notice.
subsection 5.
If the amount determined by the competent authority under the subsection 1 or subsection 2 is not acceptable to either of the parties, the amount shall on an application by either of the parties be determined by the arbitrator to be appointed by the state central government.
And 3E1.
3E1. 3E1. Where any land has vested in the central government under subsection 2 of section 3D, and the amount determined by the competent authority under section 3G with respect to such land has been deposited under subsection 1 of section 3H with the competent authority by the central government, the competent authority may by notice in writing direct the owner as well as any other person who may be in possession of such land to surrender or deliver possession thereof to the competent authority or any person duly authorized by it in this behalf within 60 days of the service of the notice.
And 3H1.
3H1, my lord, 3H. Deposit and payment of amount. The amount determined under section 3G shall be deposited by the central government in such manner as may be laid down by rules made in this behalf by that government with the competent authority before taking possession of the land. As soon as.
So basically it is 3D5. Who is now 3D5 arbitrator? Ms. Bordola? Who is now arbitrator?
Secretary.
Not by name. What is the date? Where is the notification? You get the notification. Mr. Das, you'll be there tomorrow. Will allow you to file the application for before the arbitrator appointed by the central government. You find it a notification because 3G5 this repetition is we cannot enhance.
Right.
But you have good documents in support of your claim for enhancement.
Right.
You have to place it before the arbitrator. Right, this is the law.
Right.
I can't help it. I cannot enhance it. Okay, NC does. So senior counsel state by Mr. M does. More order আছে না বুকিটা? R. Bora, Land Standing Council, NHAI. Huh?
I think it's here for one, but now I'm senior central government council.
Okay. Miss R. Bora, Learned Central Government Council, and Romanen, Standing Council.
That's it.
NH,
IDC,
NHIDCL for the respondent number 1,
4 and 5.
4,
1, 4, 5.
4, 5. Miss N. Bordolo, Revenue.
I am for 6 and 7.
Department 2. Mr. J. Henrik, Learned Junior Government Advocate Assam for the respondent number
6 and 7.
6 and 7.
A
A. Borua, Miss, on behalf of Mr. C. Borua, Learned Standing Council NHAI for the respondent number 3. And Standing Council PWD. Any Standing Council, Ms. Bordolo? Okay, ask him to appear tomorrow. I'm posting it tomorrow to for disposal. Post up. The Learned Standing Council PWD. Hard, huh? Learned Standing Council PWD. For the respondent number 8 and 9 is found absent today on call. Post up. Mr. Das, you be there tomorrow. If Mr. Das, M. Das, right? Your presence is not required. I have already heard. You are available, you come, but otherwise, no need to take trouble.
Clear, my lord.
Place the case tomorrow.
Lordship.
Dalmia যদি ফল হয়, এটা করলেও পারে।
Because already been sent to mail.
Okay, give it.
The wrong one, bullet.
You get it tomorrow?
It will again.
The 30 is same.
30 is same.
Okay, 30 is same. Same order. Just inform Mr. Mr. Goswami is PWD? You are not PWD. Same order.
Item 31.
Pranjal Sutia.
Government was supposed to file affidavit.
Instruction received, lordship, 2 weeks time.
Oh, yes, Dr. Learned Counsel for the petition is present. Mr. N. Goswami, Learned Junior Government Advocate appearing for the state respondent has submitted that the instructions to file the counter affidavit are received and has sought for how much time?
2 weeks.
2 weeks time to file the counter affidavit. The price law is the case also.
Your chair, I'm going to 5 and 6.
Given take this.
Therefore, whom? The respondent number 2,
2, 5 and 6.
2, 5 and 6 are represented by the Land Standing Council Water Resources Department.
Hello.
Maybe leadership. Will I receive copy of the evaluation of
Oh, where is Mr. Das? Let me tomorrow. I am told that item number 1 might fall. Mr. Taludar, H. Das's case, let it be tomorrow. H. Das.
I will inform us.
Oh, you are there. Tomorrow? Hey, item number is just
28. 28.
adjournment is in adjournment prayer is in item number 1. No? Okay. Now I am told that item number 1 has an adjournment. Steve has been circulated. Yes, Miss.
Today they have filed an affidavit, my lord.
Okay.
3 weeks.
You want to file reply? HR Ahmed, petitioner. N. Bordole, revenue 1 and 2. HK Hazarika, 3, 4, and 5 are present. Mr. Ahmed has submitted that he has received a copy of the affidavit in opposition of the
That's number 3, my lord.
3 and has sought for 3 weeks time to file an affidavit in reply to the state affidavit in opposition. First, the praise the law. List the case on so and so.
19th August, 1908.
Item 34 also same.
34 is same. Affidavit file,
Yes, third loss.
30%.
Item 35.
Lordship, in this matter, Lordship, we have not received the instruction. So I may be allowed 2 weeks.
RDOD, your name please?
I'm his associate,
Name please?
M. Basumatari.
M. Basumatari petitioner, HK Hazarika, 1345. Social Justice Empowerment, Mr. S. Kotsum. On behalf of Mr. R.M. Das, Lion Standing Council, Social Justice and Empowerment Department, Government of Assam, for response number 2 at present. Mr. Hazarika has submitted. What about your you're just showing face, or are you going to file any affidavit?
We'll file our affidavit.
Both Mr. Hazarika and Mr. So have sought for and are granted further 3 weeks time to obtain an essay instruction and to file their respective counter affidavits. Please the case on
19th August, 1908. Item 36.
The affidavit in opposition has filed by the respondent number 5. 2 weeks time, kindly may allow for filing reply.
reply.
My lord.
Okay, M.U. Ahmed, petitioner. J. Hendik, 1 and 3. Mr. M. Sharma, 2
Yes, your lord.
for the respondent number 2. Mr. Ahmed.
My lord.
Affidavit by respondent number 2.
My lord. And another wrong I have done inadvertently, amended cost title was not filed, my lord. It is ready. I will file in the meantime also, my lord.
Has sought for and is granted 3 weeks time to file an affidavit in reply to the affidavit in opposition filed by the respondent number 2. List the case on suits.
1708, 17th August. Item 37.
May I please your lordship? As per last order, respondent number 2.
Any affidavit, Mr. Sharma?
Your lordship, in this case, we have not filed affidavit till date.
How much time you need?
The only 2 disputed amount, one is 0.45%, another is 35 rupees.
Okay, then tomorrow.
Yes.
Either you're giving
Yes.
your name
NPR.
and Kialong. Any PKMD is there? Central Government Council? You are?
No, he is with me.
Okay, Mr. Sharma, Council for the respondent number 1 has submitted that he will place the instruction he has received. Tomorrow, place the case tomorrow.
Item 39.
Yes, non-release.
Yes, because there's some notification from the revenue department. They have to provide the receipt head of account lordship. We have made several correspondence to the inspector of schools to provide the head of account lordship that we can deposit the amount lordship.
Education is part.
Education is represented by whom? Mr. NJ Chaudhary. Where is Mr. Arbora? Okay. And a voter size. Miss R. Council for the respondent 5, 6, and 7. And Mr. N. Goswami. 9,
10, and 11. Yes.
Okay. Both Ms. Borua and Mr. Goswami have sought for 2 weeks time.
No, I have the instructions. Lordship. If they have provided the receipt head of account, then we can
Mr.
deposit.
Goswami has submitted that. You represent whom? District Commission.
Yes.
Or Kala. Basically, it is respondent number 10. as submitted on receipt of instruction from the respondent number 10, that if the, which respondent? Respondent number 6.
Yes. Inspector, yes.
Inspector or director?
Inspector, we have written to the inspector, Lordship.
Whether he is, can provide the head. Madam, has submitted that. If the respondent number 6 and the respondent number and stroke or respondent number 7 provide the concerned head of account,
Yes.
then the amount already, compensation amount already assessed can be deposited in such head of account. That is your case?
Yes.
Okay. Ms. Borua has submitted that till obtain up to date instruction regarding furnishing of head of account by the respondent number 6 and stroke or the respondent number 7 to the respondent number 10. Full stop. For to do the same. Ms. Borua has sought listing of the case after 10 days? 2 weeks. Full stop, list the case on 2 weeks. Read what they took.
10th August, 10/08. Okay. Item number 40.
Hussein Mia. Yes.
No instruction received.
I have received instruction from the DC, Your Lordship, but then I have not received the annexures. I've received the pairwise comments, but I have not received the annexures, Your Lordship.
Okay.
2 weeks time.
M.I. Hussein. Petitioner and Bordelais. 1 and Gusami 20. Ms. Bordelais has submitted that though she has received the pairwise comments, the necessary annexures are not yet received. She has sought for 2 weeks time. 2 or 3?
3 weeks, Your Lordship.
3 weeks time.
File it.
To complete her instruction and to file the affidavit. First of list the praise aloud, list the case on the interim order.
19/08, 19th August.
Pleasure.
Supplementary list, item 50.
There is no representation on behalf of the petitioner today on call. Ms. Andar and Gusami Lana, Junior Government Advocate for the state respondent is present. If you have non-representation on behalf of the petitioner today on call, let the case come up for of justice be listed after 2 weeks. So, on day 2 weeks by the office.
For orders, item 41.
Instruction is awaited, my Lordship. Posted after 3 weeks, in the meantime.
Yes.
D. Gusami.
B. Gusami.
D.
D. Delhi.
D.
Delhi or Bombay?
Delhi, my Lord.
Delhi. D. Gusami Landed Council for the review petition is present. Mr. B. S. Bora Alliance standing out as GMC's GMD for all the respondents has submitted that instructions are awaited and therefore, he needs further 3 weeks time to complete his instruction and to file the counter affidavit. First of list the case. Prayer is allowed, list the case accordingly after 3 weeks on the date will be with us.
Item 42.
Until the order is published. Office notes are there. Office notes are there. 1, 2, 3.
Notice.
Office notice, I said.
Yes, Mr. Rahman, petitioner.
Actually, my lordship, the container number 2, the district commission has been transferred, my lordship. Now the
Service is also not complete.
They will have to implement the new district commissioner.
we have already submitted the representation before the new district commissioner, my lordship.
Then implead him.
Okay, my lordship.
As per Miss N. Bodoloi, Allied Council has entered appearance on behalf of the respondent number 1. Full stop. As per office note dated 20/07/2026, service reports in respect of respondent number 2 and 3 are awaited. Full stop. Mr. Rahman has submitted that the petitioner seeks leave to file an application for impleadment of new incumbent in the office of the Deputy Commissioner Borpeta. Full stop. The leave is allowed, leave is granted, raise the case after 2 weeks. For filing of appropriate application for impleadment.
Item 42, same, my lordship.
Same.
43 is also same.
43, my lord.
43.
3.
What is the service report? Same. Service report, same.
Service report.
Same then. Same. File implement.
Item 44.
Please. Pleasure.
Lordship, we have sent the affidavit for vetting. I'm here for 10
Which
days. time.
property? PJ Talda Estate by PK Medi. 1 to 8.
Rest of the yet to be issued notice because this code restricted right now against 1 to 8 only.
Okay. Mr. Talda has submitted that, yes, vetting or
Vetting.
has sent out vetting.
Yes.
Okay, the affidavit in opposition, draft affidavit in opposition on behalf of the state respondents has been set for vetting and has sought listing of the case after
10 days. Man.
2 weeks to file the same. The above price accepted, list the case on service.
Also, we fix a date because
List the case on.
10/30, 10/08.
Rest he will do.
Deeply.